So good morning.
Good morning.
Good to see you all from all points of the compass throughout the United States, Europe, Africa, I think just about Mexico, South America, places just about everywhere except I think Antarctica. And we may still have somebody coming from there as far as I know. Anyway, welcome to Brooklyn Law School. We have looked forward to this incredibly important and impressive conference for a great deal of time. I personally was hoping, as the Dean of the Law School, and as somebody very interested in the issues that you'll be addressing, hoping to sit through here. When you see me run off, and at some point, at least for part of the day, some of our faculty run off, it's because we will be attending a funeral service for a very important person who's been with us for a long time at the law school. This woman was executive assistant to 4 deans, 11 associate deans, a colleague and co-worker with hundreds of faculty and staff members and thousands, over almost 30 years, thousands of students, hundreds of whom, as alumni, have been writing to us in the last 2 days. And so this is very much on our mind, and we'll be running off for that memorial service. And the reason I am spending a bit of a moment on it is because Mary Lee Bedford came to us after being a nun, a Dominican nun for 12 years in a convent, and a parochial school teacher. And she was a woman of deep faith, but also strong independence and an advocate for equality, and left the convent without abandoning her faith because of her strong disagreements with the church's position on the role of women. And so I know from my personal contact with her about her unwavering faith and her strong commitment to religious values, but also, her determination and independence. And so I think that her example, which is very much on our mind, is not unrelated to the very important topic of this conference. So I congratulate the organizers of this conference for putting together a program that has a wonderful duality in that it's bringing together scholars, critical thinkers, and doers, advocates, which is not all that common in academic conferences. And so we're expecting a very stimulating debate about ideas, but also then some discussions about how ideas can get tractions and make a difference in people's lives, and then perhaps the other direction when you're doing and advocating what new issues, intellectual issues are raised. So this is going to be a wonderful conference. It also reflects that in the age that we're living in an increasingly borderless, intertwinkled world, that the issues of religion and equality know no boundaries and are global. And the composition of the attendees reflects that today. We're especially grateful to the people who made this possible, the ACLU, which is headed, we're very proud to say, by our Centennial Professor of Law, constitutional legal scholar, who's also the president of the ACLU, Susan Herman, and very, very happy and proud of her at every moment, but none more than her being able to bring this here. We're grateful to Louise Melling also for the tireless work she did in making this conference possible. Our own Professor Tebbe, Nelson Tebbe, is a leading scholar in this field who is a real jewel in the crown of our top-ranked faculty, and we're very, very happy that he's able to take a leading hand in this program. There's many, many others. Whenever you start naming people, you always get our risk of missing them, so I want a blanket apology to anybody that I omit, or I'm sure I'll be corrected before too long. We're very grateful to the Yale Law School, my alma mater, and for its Information Society project, Priscilla Smith and Jonathan Balkin, who I understand are here and who had a big hand. Also, funding that we received from the Luce Foundation, Henry Luce Foundation, to make this event possible is much appreciated. And then to our own staff and students, I say thank you. They do not, we put on almost like that movie Das Boot, where you've got hot bunks. You know, we put on so many events here of the highest quality that our staff always goes above and beyond. Liz Alper has been leading this effort. There's many, many others behind the scenes to make this possible. So we thank them. And also the students on our own Journal of Law and Policy, in particular the executive editor David Giller, and our Symposium coordinator Melissa Martin. We're deeply thankful. I'm sure you're going to have a marvelous day. If there's any 2 days, if there's anything that we can do or that you need, anything at all, you know, ranging from esoteric, like your need to acquire some materials from the library to make a point, or if a storm arrives and your travel plans, if it's really a hard thing, then see Nelson. But otherwise, if you want to, I'm right downstairs. Contact me, and we'll do whatever we can to make your time here productive, pleasant, and enjoyable. And I hope you have some moments to go outside and take a look at the most exciting place in the world, Brooklyn, New York. Thank you very, very much.
Thank you, Dean Allard. I want to welcome all of you. My name is Nelson Tebbe. I'll introduce myself a little bit later, but now I'd like to just take a minute to introduce our keynote speaker. I'm a huge fan of his. There is no bigger fan of his than I am. Abdul Ahmad An-Naim, as you all probably know, is Charles Howard Chandler Professor of Law at Emory University School of Law. But he's also Associate Professor in the College of Arts and Sciences there. He's Senior Fellow of the Center for the Study of Law and Religion at Emory, and he's a Fellow of the Emory University Center for Ethics. He's an internationally recognized scholar of Islam and human rights, and of human rights in cross-cultural perspectives generally. He teaches courses in international law, comparative law, human rights and Islamic law, and he does research, conducts research in constitutional law and constitutionalism in Islamic countries and in African countries. He also is a scholar of secularism generally and Islam and politics. His book, Islam and the Secular State, which was published by Harvard University Press in 2008, has been translated into and published in Arabic and Indonesian. Translated versions of the manuscript in Bengali, Persian, Urdu, Turkish, and Russian are available for download free of charge on the internet. It's been a widely influential book which argues for the compatibility of Islam and human rights. And that argument he owns and is justly famous for. His current research focus is just as exciting, though, and it looks at American Muslims and citizenship. And that research will culminate in a book called What is an American Muslim? Embracing Faith and Citizenship, which is forthcoming from Oxford University Press. So I hope you'll join me in offering a very warm welcome to Abdul Ahmad An-Naim.
Good morning, and thank you all. And I wish to begin with extending my condolences to the community on the loss of your colleague. I think it's moments like this that brings communities together and bringing our sense of the fragility of life and exactly why we should take it so seriously and to try to make the best of it as we live, because we never know when we will depart. I'm grateful for the honor and privilege of starting with these opening remarks. It's always a bit of a burden to think of a keynote speaker, that what are you supposed to do? But I think what I would like to do is what I probably do all the time, which is just to offer some of my own personal reflections And I take my task to be to provoke, to challenge, but it is not my intention to offend. So please, if something I say sounds a bit too much for you, bear with me and sort of blame it on the passion of an African Muslim from Sudan who's been a human rights activist for 40 years. Some friends in the room also are really delighted and honored to note their presence. I'm grateful for it. Usually it is helpful to start with the title because it gives you a sense of what at least the organizers are thinking about the scope or the issues that might arise. And I think the question of religious freedom and equal treatment and an international look is something that raises in my mind 3 levels at which religious freedom and equality of treatment can be discussed, examined, and also acted upon. One is the national level, meaning however incoherent, however inadequate that national level may be, as it is in many of our countries in Africa, but at least in this country it is coherent enough and dynamic enough for some organizations like the ACLU to really excel in pursuing the question of freedom of religion or religious freedom and equality at a national level in ways that are extremely important and practical, right on the ground, where it should be. But then there is the question of, when we think about looking at the subtitle and an international outlook, the question is, when you look out from your national experience internationally, that's where I think you need to be careful about how you approach the subject and whether you are projecting your national values internationally or not, and that is the danger of it. When in particular, when we are, like what I will note, for example, briefly here, the so-called the American International Religious Freedom Act, which there is nothing international about it except its title. I mean that the point is that American Congress is defining international freedom of religion and the implications of it internationally for everybody else. And that's what I mean about the risk of imperialism. And imperialism is really very close to us. I mean, we should never really forget the danger and the risk. In fact, we can be imperial in our interpersonal relationships, let alone our national politics and so on. So it is an attitude of thinking that you have the answers, that you would like others to follow what you are saying just because you are saying it without persuading them to really accept the point. The third level I would suggest is when we look at religious freedom and equality of treatment at an international level of which our national is a part, meaning that we are not looking out to international freedom of religion and equality of treatment internationally, but we are looking at a shared venture of which we are a part in an international effort to protect freedom of religion and equality of treatment. And that is the level where human rights are relevant. So the first two have nothing to do with human rights. And I think that you may find that shocking, but let me try to explain in a few minutes. But the point is that the third one is where international human rights standards and norms and institutions and movements might come into play. But the first two are not. The first two are domestic civil rights, constitutional rights, but they are not human rights. For the simple reason that they are the rights of citizens, not the rights of the human. And that the process by which we define and the process by which we protect or implement those rights is premised fundamentally on our national constitutional and legal systems and their ability to protect certain rights. So and at this level, actually, the national, this is not to belittle or to try to imply that the national is not significant. Actually, because the national is ultimately where all violations happen and all protection and remedy can materialize. That is when we talk about international human rights, we are talking about them as a means of getting to the national, not as an alternative to the national. Human rights are always violated within the territorial sovereignty and domain and subject to national jurisdiction of states. And it is only dealing with that that's where we can bring relief and remedy to the victims. So we cannot avoid the national. It's just that whether the national is also part of a global initiative or not. What I'm thinking about this idea of the locality of violation and of remedy is to pay tribute to organizations like the ACLU. And again, it is not because the director just walked in here or that this is an effort that is co-sponsored by the ACLU. But in my mind, with all due respect, I take the ACLU and its siblings. No, it's not only the only one in the country, but organizations like the ACLU to be more important for the protection of civil rights than the Supreme Court. Because Supreme Court can only just sit there. If something comes its way after 5, 7, 10 years from when the issues were alive in people's lives, it might have occasion to say what the 9 justices happen to think civil rights are about or what they mean in the case. But it is the daily struggle of protecting human rights and freedom of religion, and civil rights in a very concrete, down-to-earth level. That's where the real meaning of civil rights gets to be realized. And that's why I think the organizations like the ACLU should be celebrated very much. But also to realize that it is a negotiation, that what civil rights are, like freedom of religion, is not a fixed meaning. It does not have a fixed meaning throughout life of a community or several generations even of that community, but that is a constant struggle to define and redefine, to affirm and reaffirm. And the day that we stop redefining or reaffirming is the day that we lose the right. It is no longer the right that we aspire for if it is not something that is so live and so fragile that we have to keep protecting and looking for making it relevant, making it legitimate, making it useful for people's lives. One other aspect about what I call constitutional civil rights is that they are relativist. They are relative to the society, to the community, to the time and place. And they can never cease to be that. I mean, there is no way that you can have your national standards universal. They are, by definition, being national means being relative. And relativity is not something that is to shy away from. It is the fact of human consciousness and awareness that every single human being, everywhere, is a relativist. There is no universal human being. Every human being is a product of her culture, of her history, of her context, of her class, of her education, and all of the things that make her who she is. So to think that we can somehow become universal by affirming universal values, when we affirm those values, we affirm them from our perspective, which is a relativist perspective. And whether they do not become universal just by simply the fact that we affirm them. But that universality has to be constructed and struggled for and sustained over time. Now, if I may, so I'll just keep going on to highlight the various aspects of these 3 levels and so on. I think that we should also try to consider the fact that civil rights are at odds with human rights, conceptually as well as practically. Meaning, as a matter of concept, because as I said, they are the right of the citizen, not the right of the human. And living in this country, I'm sometimes struck and saddened by the fact that our administration, our media, is so blatant about the fact that this is so because an American citizen was involved or is involved. I mean, so the idea that we can engage in assassinations, targeted assassinations, or drone bombings, and so on on other people in other parts of the world without regard to anything. But we can't do that for the citizen. We can't target an American citizen approach. But to me, yes, we can't and shouldn't target an American citizen or target a human being anywhere. So that is what I mean about the fact that civil rights, because they don't take the human as such, but they look at the citizen. And as a matter of practice, because we are looking to national institutions to protect them, which is fine, but I think it's also ultimately limited and has no pretense of trying to speak of a universal right, because when we are protecting what we believe to be civil rights in our national institutions, as ACLU and others try to do, that is very good and exactly what we have to all be doing, but we should not confuse that with the notion of human rights as I see internationally. Now, if I may move on, and of course I hope that I will leave enough time for discussion and questions and so on. The question of equal treatment, for example, for me is just to highlight it here in terms of we tend to think that equal treatment is self-evidently civil right at this in the national level, and if it is internationally an international right. But we don't think often enough, I think, of equality of treatment regarding what and for whom. Because it is not equal treatment for every human being regarding every aspect of being a human being. We tend to highlight and focus on certain aspects of our humanity to insist on equal treatment about or on, but overlooking others without even bothering much to explain or thinking that we have to explain why. And the obvious example here is that there is no talk about equal treatment regarding economic conditions or economic rights. So yes, we have equal treatment as a civil rights value regarding gender, regarding race, and these things are things that came about over time. They were not self-evident or implicit or embodied in the Constitution to begin with. It took civil wars and it took constitutional amendments to make them civil rights. So that is true, but also that we don't do it across the board for everything. And to bring an example here that is recent but shows both the dynamism and the incrementalism of the process and the negotiatedness of the process is the gay and lesbian rights. This is something that is so recent. You know, even I remember I was here in this country when it was not a civil rights issue and has come to be a civil rights issue all the way to the Supreme Court over the last 15, 20 years at the most. So was equality regarding sexuality a civil right or not a civil right before it got to achieve this national presence and consistency? And still, it is not, the struggle for it is not over yet, and we never know what might be around the corner regarding a backlash here or there. But the point for us is not this right in particular. It is right. It is more the point about how civil rights are dynamic and evolving. And if they are, they can also regress. And we have to, again, reaffirm our commitment to these values with every generation, as Jefferson would say. Looking at the idea of projecting our understanding of whether it is freedom of religion or religious freedom rather, or equality, is we have to be very careful about the imperial posture. And as I said, imperialism is a very close by risk. It is something that we all have to live by and we have to constantly try to overcome. It is not something that we can overcome once and for all. But we have to remember that the reason why it is not going to work when you try to project your values abroad is historically because of colonialism, because that was what colonialism came to Africa and Asia to try to at least pretending to protect and to present. I mean that whatever level of justification colonialism sought, it was in terms of protecting minorities and coming in to improve the human quality of life for people and so on. So that colonial history is very much present in people's minds. And then they will see it whenever you have this imperial projection of values. And also it can also be neo-colonial, because that's also something that we tend to think of. We were not colonial. Of course you were colonial. The United States was a colonial power. There should be absolutely, if you don't know that, then you don't know American history. You don't know the Philippines. And you don't know even further back other things that happened. In fact, it is colonialism in the classical sense of displacing local populations. That's the foundation of this nation. So we should be humbled with that. But the point I'm making is simply just to be aware of the danger of trying, because often I make this sometimes to students and friends, and to say that we tend to assume that if our human rights advocates, that somehow makes us noble, makes us better human beings. And it doesn't. And it's very dangerous to think that being a human rights advocate means that I am a better human being for that fact. It is just, in fact, the conceit of it can be even more dangerous and so on. So we should not assume that because we subscribe to these values and because we respect them and we try to live up to them, that immediately makes it true in our case that we are that level of humanity. Now, coming to the third level of thinking of our national sort of freedom, religious freedom and equality of treatment, to be brought into being part of a global level, an international level. That's the only level when the human rights idea can be evoked, really. It's only in that sense that freedom of religion or religious freedom and equality are human rights, not just civil rights. And when I say not just civil rights, I don't mean to diminish the value of civil rights, but simply to say that they are different. Different in sources, different in institutional implementation, different in the level of commitment that people have. People tend to have more commitment to their civil rights than they do to international human rights. Now, when we come to the international human rights dynamics or dimension of the title of our conference, then I think we should be talking about something that is recent, radical, subversive, and universally inclusive. And maybe it has to be radical and subversive because it claims to be universally inclusive. And by this I mean to suggest that human rights are not just simply what the Universal Declaration says they are. And they do not become human rights because the United Nations or states got together to draft a treaty and adopt it as human rights. This just happens to be what people think human rights are at the time in the context. And in this sense, not all people were part of the process of defining what those rights are. So I think what I find difficult for myself and other colleagues and friends who work in the human rights field is we find it difficult to understand that what we think of human rights is not necessarily what other people think of them. And in fact, it could be the opposite. And the point in which I think I would like to be most challenging is to say that there is nothing that makes our understanding of human rights more sacred or more valid than anybody else's. And that we must be prepared to accept a fundamental challenge to any right of the rights that we think we believe in. The point for me here is that who is the human in human rights? It is a self-determining human. Meaning that the human being that we are, of course this is a normative point, not an empirical point. Meaning that I'm not saying that all human beings are in fact self-determining. In fact, it may be hard to find any human being who is truly self-determining in every respect and so on. Because there is so much sociological and economic and political and other factors that diminish our self-determination sense of self-determination. But the point I'm making is that when you say human rights, the human in this phrase is a self-determining human. It cannot be someone for whom we can define what the rights are. It has to be someone who defines the rights for herself. She may agree or disagree with whatever we are suggesting for her to consider, but she has no obligation to accept our suggestion of what human rights ought to be for her. She has to accept them for herself. The only way that we can make it a human right for a self-determining human being is to be persuasive about it, not to be coercive. And coercion, by the way, is in this field is utterly useless and also counterproductive. It never works anywhere. You can invade countries, you can kill hundreds of thousands of people, and when you leave, and even while you are there, human rights, as you think they are being violated. And there is nothing you can do about it. Even when you occupy a country like Afghanistan. You are not going to send a military escort for every single girl to go to school. You are not going to protect women against domestic violence or intimate violence, as sometimes the term is used. You can't and you won't. And we see the stories, sometimes they come through in the news, but we don't draw the right lessons from those stories and those narratives. So I think that the idea of human rights, in case some of us are not aware of that, it has to be radical. Because it is about fundamentally challenging the dynamic and power relations of every community and every society. If you want to achieve human dignity for everyone, you have to take away power from some of the people who take power for granted and assume that they have the right to exercise power over others. And you have to take away privilege from some people in order to share it with others. And wasn't Gandhi who said there is enough for everybody's need, but there is not enough for everybody's greed? And whether it is in this country or in this town or across the world, it is the same issue, that you have to challenge existing power relations. You have to challenge existing economic relations. And that takes me back to the question of when we say equal treatment, are we including economic equal treatment, or are we only being selective about what treatment we choose to be equal about, and so on. Now, the universality idea is absolutely essential for the concept. So otherwise, in other words, you may or may not have human rights. We may or may not realize this vision. But if it is to be realized, it has to be universal. Because it is the right of the human. So it may be, and I'm beginning to think more and more likely that this venture will in fact fail. Because in 60 years we have not really started even to do it properly by truly confronting the demands of what it is to pretend to protect human rights. Our institutions, our organizations, our personal lives, all of that is involved. And it is a personal lifestyle as much as it is a power relations question across the world. And so I think I'm beginning to say that, okay, it may fail, and so there was a world before human rights, and there will be a world after human rights. If human rights are not relevant enough for people to want to sustain and struggle for them, then they are not worth having. And there is no real sadness over their loss. But if they are of the value that we claim they have, then people will stand for them, and people will sacrifice to protect them and to respect them, and to have them protected and respected. But the idea is that the concept itself is about universal rights, and the concept itself about universal implementation. And here comes the real challenge, I think, what I call the paradox of universality, is in the reality of diversity and pluralism. That we tend to disagree about what human rights are. In this room, I think we will. If you talk about certain rights, you will find people who think of that right as more or less than what you think it is. And that will remain, and that is in part of the self-determining dimension of it. But I think the point is to understand that consensus has to be achieved through dialogue and discourse and solidarity and collaboration. It is constructed, it is not proclaimed. And when you come to think of the proclaimed, I mean, the University Declaration was proclaimed in 1948. How many African states were at the UN at the time? 4. Egypt, Liberia, South Africa, and Ethiopia. Ethiopia was Imperial Ethiopia. Egypt was the monarchy. Liberia was what probably some of you may know Liberia as it used to be. And South Africa is almost apartheid South Africa. It was just within a year or two that apartheid became totally legally the legal and constitutional system of the country. That was the extent of African presence at the proclamation of the University Declaration. The rest of Africa was colonized by the same powers who were proclaiming the University Declaration in Paris. France continued to colonize and impose its will on Algeria for almost another 16, 15, 17 years. From 1952 until 1962, France suppressed an Algerian war of independence in which 1 million Algerians were killed. France, the home of the French Declaration of the Rights of Man and Citizen, and where the University Declaration was proclaimed, continued to colonize until 1962 with tremendous ruthlessness, practicing the same strategies that Nazi Germany practiced in France, of collective punishment, of torture, of all sorts of atrocities that were committed by France, by the French state. So we have to be very sober about what we mean and what the level of our commitment is. But absolutely to understand that proclaiming a right does not make it so. If you don't live by it, then to you it is not a right, let alone to anybody else. So that I think why I say that they are recent. We don't have any experience of them before the decolonization process, which took some time. It's not only 1948 when the 50 or so members of the United Nations were mostly colonial powers themselves proclaimed these rights, but we, the rest of us in Africa and Asia and Latin America, still, were trying to come to the table, trying to be part of the conversation. And until we do, and until our voice counts equally with everybody else's voice, then what we're talking about is not universal human rights. Now, so I would conclude so that we can have more of a discussion is that when we ask what is a human in human rights, it is a self-determining human. What is right in human rights? It cannot only be legal rights. It cannot only be liberal perceptions of rights, because those are relative values and relative institutions. They are not universal. So liberal notions of right is relative and imperial and colonial. Most of us got it through colonialism, and not got it in the sense of totally came to accept it, but it came to our world, in our consciousness, through colonialism. But by no means it's universal. The idea of legal rights also assumes a lot. It assumes sort of judicial and civil society types of partnership that the ACLU with American courts and so on are doing in order to protect the rights of a few people retroactively over time and in a very expensive fashion. That is, when you think about human rights as we seek to protect them through the courts, there are going to be a handful of people who have somehow the ability to reach powerful actors or organized actors who can act on their behalf. But the vast majority of people whose rights are being violated have no means of reaching instruments or situations of judicial protection of rights. So pursuing judicial protection of rights as if it's a goal is really quite unfortunate. I don't know how to call it, because who is going to benefit? You know, I am from Sudan. I lived 40 years of my life in Sudan. I left after that, but for 40 years of my life I lived in Sudan. I traveled in many parts of Sudan. There are no courts. There are no police force or public prosecution. There is no presence of the state, except in the most oppressive sense of collecting taxes and suppressing any local rebellions. But the state as an institution that will provide remedy and relief, you travel for days, you never encounter a single symbol or element of presence of the state. And yet we are expecting the state to protect the rights of Sudanese against the Sudanese state itself, when it doesn't have the means, or even pretend to have the means, or care to have the means. So that's why legal protection is extremely limited. It may be necessary, I think it is necessary, to give some credibility to the notion for those who care to worry about this sort of thing, but not for the vast majority of people in many other parts of the world. And then when you look, therefore, come to the more specific, when you talk about religious freedom, which religion are you talking about? It is only North American, North Atlantic Christianity. That is, there is no conception of religion and what it means and what freedom of religious freedom means for people who are not of this tradition, who do not belong to churches and define religion and understand religion in the sense North Atlantic societies do. China, where is that? India, where is that? In terms of, now, of course, I mean, you will get the Chinese and the Indians coming to join in that sort of very limited elite who seek legitimation through this process, who are trying to be part of one of the voices on the question of what human rights are and so on. But for the vast, vast majority of Indians, for the vast, vast majority of Chinese, for the vast, vast majority of Africans, religious freedom really is incoherent. It may or may not be good, but they never got to that. This is not something that they worry about or something that is of immediate concern to them. So I think we should keep it national and see what we can think about it in terms of beginnings of some dialogue about religious freedom internationally, but not to pretend that we already have the standard and all it just takes is the question of implementation. For me, therefore, the notion of rights is political and moral, primarily, not legal. Legal is incidental. And legal assumes already that we are at some level of building institutions and creating legal cultures. But those legal cultures and institutions are not universal in themselves. I mean, they are really quite alien and quite limited in their scope. So we have to look for, if I talk about political and moral, talking about solidarity, we're talking about cooperation, and I think those are questions that we need to ask and we should pursue. So to conclude, I said it already once, so I promise, this is the last thought. The last thought I would like to bring. Because I'm sure that in your mind, you say, how can, he's a Muslim, how can he be talking about this? Because being a Muslim has to be by choice and conviction. If you are not a Muslim by choice and conviction, you are not a Muslim. Now you will know that there are places where they coerce people, and there are places where they execute people who are heretics. But the point is that what they do is not being Muslim, nothing to do with Islam and being Muslim. It's just power. And power will vindicate itself and perpetuate itself in whatever means that are convenient and expedient. But the point is that actually the opening sentence, maybe it says it well because I spent a lot of time trying to draft it. The first sentence of the first chapter in the book Islam and the Secular State that was mentioned is that I say that to be Muslim by choice and conviction, which is the only way to be a Muslim, I need the state to be secular. By a secular state, I mean a state that is neutral regarding religious doctrine. So my point is that my being a Muslim has to be a choice. You cannot believe if you cannot disbelieve also. So the ability and the right and the opportunity to disbelieve is integral to the possibility of believing. Belief has to be, in any religion or in any doctrine or ideology, belief has to be a choice. If you have no choice but to believe, then it is not belief. And it doesn't count anywhere. So if that is the case, therefore, the notion of an Islamic state that should enforce Sharia is nonsense. It is conceptually incoherent, historically unprecedented, and practically untenable. There has never been and will never be an Islamic state. The state cannot be Islamic for the simple reason that there is no agreed criteria of what it is to be Islamic for the state, and no means of verifying whether a state is or is not Islamic. So what does it mean to be Islamic? Because I'm running out of time, let me just put it in these terms. Iran and Saudi Arabia, they both claim to be Islamic states, but they are heresies to each other. To the Wahhabis of Saudi Arabia, Shia Iran is a heresy. For the Shia of Iran, the Wahhabi doctrine is a heresy. So we have two heresies claiming to be Islamic states. Which of the two is Islamic, and what does being Islamic mean? So the state cannot be Islamic. Now my difficulty is that not that many people believe it is, because that doesn't make it so. Meaning that when people used to believe that the earth was flat, that did not make the earth flat. And now the fact that some people believe that there is a possibility of an Islamic state, this is a post-colonial discourse based on a colonial notion of the state and a colonial notion of law. It is not of historical Sharia as Muslims used to use and practice it, and it is not of the states with which Muslims lived for 1400 years. It's a post-colonial. It's a discourse that you will not find in any sources before the mid-20th century. It is not there. The term, you can look for it, you will not find the term Islamic State or enforcement of Sharia by the state. So therefore, my point to conclude is to say that I need human rights as a self-determining human being to live by my understanding of what it means to be Muslim. And to me, this is what religious freedom is about. And about equality of treatment. In this respect, I demand equal treatment. And it's not that I ask for it, I demand it. Whether I realize it or not is not the point, is that it has to be demanded. And ultimately, I call, or rather quote, Albie Sachs. I'm sure that you know him, Albie Sachs, an African jurist, who said, human rights are about the right to be the same and the right to be different. So my right to be different is integral to my being human, integral to my being a human rights subject. And that's, I think, the sense in which we can hopefully pursue our discussion. And thank you very much for your attention. Thank
you. If anyone has any questions, we do have a few moments for discussion. I can begin. Okay, go ahead. Alejandro.
Well, I wanted to ask a little bit rather than provoke it. I think it's an honest question because I've heard I'm pretty ignorant about Islam historically, but I've heard the claim being made that there's a peculiar difference between and I've studied the Christian, particularly the Catholic tradition of the North Atlantic much better. And I've heard a claim that I think you were alluding to about the historic isolation of Islam from the state and how it is unprecedented to claim to have an Islamic state. Now, what I'd like to understand, more than historic examples, is from the theological perspective, how this is grounded. I mean, I think that from the Christian tradition, very early on, there is, and very early on, 200-300 years into the beginning of Christianity, there's this very clear marriage between the state and religion, whereas apparently that doesn't happen in Islam for historic reasons. So I'd like to ask you to flesh this out a little bit more in detail, because it's something that I keep bumping into and do not quite understand.
Okay.
And that may be because I was born and lived in the time of this historic exception in which states do claim to be Islamic.
Yes. The reason, actually, as I see it, is simply the nature of religious authority. The nature of religious authority has to be in the eyes of the beholder. That is, you cannot have religious authority to me unless I accept your religious authority. Therefore, religious authority cannot be institutionalized. You cannot have an institution that proclaims religious doctrine, with all due respect to the Catholic faith, maybe. But in my view, the very idea of institutionalizing religious authority is a contradiction. It is incoherent. Because people come to hold that position by virtue of political and sociological maybe reasons, but not religious reasons. Meaning that they don't have to persuade me as a believer why this is the religious doctrine. So now Catholic, maybe that's an example to cite, more familiar to people, that the Catholic, there is a council of doctrine, or the Catholic doctrine, or some, which proclaims religious doctrine from time to time, and it comes down to Catholic congregations who have to accept it because the Vatican said so. There is no Vatican in the Muslim tradition. And there is no type of institutionalization of religious authority that makes it issue a decree that is binding on every believer that this is the law of Sharia because they said so. So the idea, therefore, what is Sharia is what I, as a Muslim, believe and accept it to be. Otherwise, I will not be accountable for it. So to me, that is the theological reason. Now, you might find sociologically that people tend to prefer to follow someone to tell them what the religious doctrine is. But that is not theologically required. That is sociologically a fact of underdevelopment, of lack of education, of various economic disempowerment, various factors that make people more comfortable following someone else than deciding for themselves. But even if they do, they never abdicate religious responsibility.
Suzanne.
Yes, thank you.
We can follow up. Yeah.
Thank you very much. Sorry. Yes, my question is the following: who has the right to articulate who is a Muslim? Because I very much appreciate your definition of religious freedom as a choice, but this voluntaristic dimension is really typical of Christianity. I know nothing about Islam, so I am very sorry that I can't contribute to this part of the conversation. But there are other religions. I'm thinking, for example, of Orthodox Judaism, where the voluntaristic dimension is really not the predominant dimension. So my question to you is, what room do you leave to collective claims within the human rights discourse?
On the question that I understood to begin with is, who has the right to define who is a Muslim? Nobody. Nobody, because you never know what is in someone's belief or practice even. So you cannot judge someone's piety, you cannot judge someone's religious belief, because it is intimate and private. And therefore, even Pakistan, I mean, it might be maybe a little known that in the early 1950s, when first Pakistan became a state and they were trying to define who is a Muslim for the constitution, and they established a commission called the Munir Commission, Munir, M-U-N-I-R, Munir Commission. You can Google it. And the Munir Commission worked for 3 years and could not come to a definition of who is a Muslim. And they concluded that to every community of Muslims in Pakistan, other communities at some point are not accepted as Muslims. So by the same token that people tend to exclude and include other people, you find that there is no real possibility of having an authoritative, definitive authority that explains and decides who is a Muslim and who is not. And in fact, it is a form of shirk, meaning it's a form of idolatry, the word I always struggle with, idols, worshiping idols. To associate to claim that you know who believes in God as God knows who believes in God is actually a heresy. It is something that only God can know. And therefore, no human being should try to claim to decide. So that is the thing. But the point I should have made to follow up on my earlier remark is to say that the state is secular. By definition, whether we call it Islamic or not is immaterial. State law is secular law by definition. It cannot be Sharia as such. Therefore, the realm of Sharia is the realm of private practice, the realm of believers struggling and striving to live up to their conviction and belief, for which they are accountable before God and nobody else. So this is the sense in which I think we should correct this post-colonial phenomenon of thinking that we can define what Sharia is in order to enact it. And the reason is that I teach Islamic law and I am living with this constantly, that the point is that what is Sharia for the state to enact on any issue is extremely problematic because there is no agreement on fundamental questions. And therefore, for example, just very quickly for lawyers, that the crime of zina, which is extramarital sexual relations, is a capital crime according to Sharia understandings, but how to prove it is it a requirement of 4 witnesses to the actual act of intercourse, or confession by the culprit. Meaning, if the person did not confess, then you have to have 4 witnesses to the actual act of intercourse. Not just simply seeing 2 people lying naked in bed, but seeing the actual intercourse between the 2. This is according to 3 Sunni schools, the Hanafi, the Shafi'i, and the Hanbali. The Maliki school, which prevails in West Africa, accepts circumstantial evidence. So, proof of pregnancy without proof of marriage, to the Malikis, is sufficient to convict of this crime. For the other schools, it is not enough, not only that, but it constitutes another capital crime of unproven accusation of zina. So you have a position where 3 schools demand 4 witnesses, as the Quran says explicitly. 1 school is willing to accept circumstantial evidence, which is Sharia. If you enact this view, you are denying people who believe in the other view. If you enact that view, you are denying people who believe accept this view. So because of that, and because it is throughout the system and the jurisprudence, it's not an isolated example, it is so difficult to define what is property, what's a contract. There are differences. And therefore, if you enact any of it, you will by definition be making a choice among competing claims. And that should not be the way that you can enact Sharia.
Thank you. I want to thank you for a very inspiring talk. And I follow many of your statements, like the fact that in the whole picture of trying to realize human rights, the work of lawyers and certainly the work through the judiciary is actually rather marginal. So we should probably have, well, maybe not less human rights in the law schools, but certainly more in the other schools. And I also follow where you say that the universal human rights, if we really want those, we should really take also the views from outside the global north more seriously. But you started with drawing this sharp distinction between civil rights and human rights. And in my opinion, that's a relative view. That's not a universal view. I can see how this is a truth in the United States of America. But from where I come, my relative view in a continental European country, Belgium, where domestic courts constantly apply international human rights law, it's the same thing, civil rights and human rights. It's really the same thing. And for example, in the universities, the human rights institutes were born in the departments of constitutional law, because for all practical purposes, constitutional rights have been replaced by European Convention rights. And so for all actors, the rights holders, the court, the state that wants to respect human rights, it will look at these different levels, national, European, global, at the same time. So that's a different reality where I stand, in my relative view. But I do think, I mean, your main point still stands in the sense that there is a tension between the national level and this global universal level, and that this is very much at the heart of what we will be discussing these 2 days, which is that the universal level, I mean, has to be universal. So it's sort of the minimum. Nobody can get below that line. But at the national level, of course, you can do more. You can do a lot more than the universal. And so this is at the heart of discussions we will have at the European level about margin of appreciation to the states. Where should the European Court draw the minimum line? What should be that minimum? But for instance, also about LGB rights, where, as you mentioned, you refer to the incrementalism at the national level in realizing these rights. This is so true. And once we're there, like once we had gay marriage in Belgium, we all forget how long this has taken us, how difficult this has been, and we start sort of pushing the rest of the world to have it as well, because we think it's such a great thing. So a question about the relationship between those two levels, the domestic and the global, is also like, what do we do with this? Can we bring this realization of incrementalism, of step-by-step approach to the global level? Yes or no, and how do you do that? So I guess it's maybe more a comment than a question, but maybe you have a comment to the comment.
And the comment is appreciated, but I would like to draw your attention to how recent this is. When you say in Europe the civil rights and the human rights have come so close, they have come close enough so recently for so few people over so little issues. It is not like, how far back do you go? And I'm not talking about European citizenship or European entitlement. I'm talking about the non-European in Europe. But also for Europeans, I mean, what was the Oromo in France 2 years ago? How come that you expel a whole community and population? If you have a commitment to human rights as right of the human, not the right of citizen, that would not have happened in France and in other European countries, and where really leading European states look the other way. So again, it is not to say to belittle the achievements of Europe for Europeans, but to say that let us be modest about our claims for the rest of humanity on behalf of the rest of humanity, and to realize that when other people say no to our pretensions to impose what our values are on them, they are in fact exercising their fundamental rights to be self-determining. And they will have it whether we like it or not. The thing is, we have to be clear. I mean, it is not about, if I only insist enough and keep pushing, they will have somehow a seat, or bring a few to education and so on, and spread that. When you said schools, most places in the world don't have schools, so whether law schools or otherwise. So it is just simply a call to humility and to understanding the limitations of our discourse, because we can deceive ourselves into thinking we are superior, we are doing the right thing, and forget that the vast majority of humanity are not touched by what we do.
Terrific. There are a number of people who'd like to ask questions, but maybe we could defer that until later. But thank you so much for your comments. Okay, so at this point we can kind of shift gears and turn to our first panel. The topic for the first panel, as you know, is religious freedom, expressing religion, attire, and public spaces. And we have a distinguished group of panelists. Let me tell you a little bit about how we envision this working just logistically. So in the first half of the first panel, we will hear primarily from non-academics, that is, lawyers who are active in this area in different parts of the world. Some of them not even being lawyers. Yeah, some of them aren't even lawyers, right? Thank God. Then we'll have some discussion and then we'll take a little break. We'll come back and hear from the second half of the panel, who are bringing a more academic perspective to this topic or set of topics. And then we'll have sort of more discussion, and we'll end in time for lunch. So what I'll do is kind of introduce each of our speakers, and then kind of moderate the panel. They've agreed to limit their comments to about 10 minutes apiece, so we can have plenty of time for interaction and discussion after the first set of comments. Again, we'll take a break, and then we'll hear from the second set. So let me begin just by introducing everyone. We're going to go, if it's okay with everyone, a little bit out of order because Hassam's notes are still being printed, he's told me. So first we'll hear from Shami Chakrabarti. She is Director of Liberty in the United Kingdom and has been since September 2003. She's a barrister by background, and she's worked as a lawyer in the Home Office from 1996 until 2001 under both parties. Since becoming Liberty's executive director, she's spoken and broadcast widely about Liberty's work on equality, human rights, and the rule of law. She is chancellor of Oxford Brookes University, which, putting things together, I think makes her Lucy Vickers' boss. Yes. She is a governor of the British Film Institute. She's a visiting fellow of Newfield College, Oxford. She is a master of the bench of Middle Temple. Which sounded both impressive and a little bit scary to me. I don't know what that is, but we don't have anything like that here. I want to welcome her. Next, we'll hear from Haggai El-Ad, who is Executive Director of the Association for Civil Rights in Israel. Prior to joining that organization in 2008, he was the first Executive Director of the Jerusalem Open House for Pride and Tolerance, which is a community advocacy center on the city's LGBT community. He launched in 2002 what has become Jerusalem's annual Pride and Tolerance March. He was born in Haifa, and he was a predoctoral fellow at the Harvard Smithsonian Center for Astrophysics, which makes him, as far as I can tell, literally a rocket scientist. Hossam Bhagat is the founder and director of the Egyptian Initiative for Personal Rights, which is based in Cairo. It's an independent organization defending human rights in Egypt. Since the 2011 revolution, the organization has expanded its scope to work on transitional justice issues, the protection of civil liberties and political rights, and the promotion of economic and social justice, as well as reform of the criminal justice system. He has training in political science and international human rights law. He's a board member of the International Network for Economic, Social, and Cultural Rights, and a member of the board of directors of the Fund for Global Human Rights. So with that, we'll begin with Shami Chakrabarti.
Well, thanks very much for that very kind introduction. A brief translation would tell you that Liberty is the National Council for Civil Liberties. It's the slightly poorer and smaller and younger sister of the American Civil Liberties Union. Younger, Anthony. Sister of the British sister of the ACLU in the UK. We are the domestic campaign for rights and freedoms in the UK. Middle Temple is a bit like Hogwarts. And yes, I was a lawyer, but in recovery, or perhaps one never recovers. Perhaps I'm in remission. But I certainly, the way to do that, by the way, is one drink at a time. But I certainly agree, more seriously, with the suggestion that for human rights to really animate our various societies in a positive way, they have to live not just in the courtroom, but in the classroom and the living room and the Parliament chamber and the boardroom and the police station, etc., as well. And that's a very, very poor way of paraphrasing the sentiment that we all know from Eleanor Roosevelt about small places close to home. And I think that this topic in particular is very relevant to making human rights real for people in small places close to home, not just in Guantanamo Bay or various other dramatic places where we've sometimes had to be dragged, haven't we, Anthony, over the last decade. I often feel like a Corleone Don in whichever movie it is where he says, I try to go legit and they keep dragging me back in. We keep getting dragged into this anti-terror narrative and discourse when it's equally important, sometimes more important, to make human rights relevant to other debates in modern societies about how we can rub along together. And I think this topic of religious freedom and equal treatment and the rubbing points and the tensions between freedom of thought, conscience and religion on the one hand, incredibly important, and equal treatment and new progressive consensuses about the rights of women and gay people in particular is very important to that. This discourse has become very important in my country, in the United Kingdom, over the last decade, I guess for a number of reasons, partly the anti-terror discourse, partly just the shrinking, interconnected nature of our world, with kids in Bradford and Birmingham feeling just as connected to the worldwide Ummah as they do to their school pals and their neighbours, and that's incredibly important in my view. It's very important not to draw too many bright lines in the sand and ask people which side they're on if you can possibly avoid it. And I think obviously there are tensions between certain versions of certain religions in particular and this more, some of us would say progressive consensus on the kinds of equal treatment issues that we are discussing. So particular thanks then to the Brooklyn Law School for having us and hosting us, and to the ACLU, our big American sister, and to Louise Melling in particular, who hasn't just sort of worked on the vision and logistics of this conference, has, in my experience, a slightly more nuanced and reflective approach to this kind of topic than one doesn't always see that kind of nuanced approach amongst litigators and civil rights activists, particularly in this country, if I might say that. I'm not looking at you, Anthony. I just get drawn to you. What can I say? So, and one more thank you to my own learned friend and great colleague Corinna Ferguson, who worked with Louise on the vision of this conference. If you look in your conference papers and see the papers that we put in, that's our interventions in the Court of Human Rights on some of these issues. And a talk that we did in 2009 on faith in the workplace and the outcomes from those courts. A lot of that work and that thinking did actually come from Corinna, who's a great lawyer but also a more reflective human rights visionary. She's not here because she's gone and had a baby, which I'm told is a human right as well. So you got me instead. So definitely agree with the learned professor that human rights aren't just a legal framework, they're an ethical framework. They're a bit of a moral compass, but they don't give us magic solutions to really difficult problems. They hopefully help us negotiate, I think, Professor, was the word that you used, a framework for negotiation, for attempting to settle very difficult rubbing points at different moments in time in different societies. And I do think that the human rights framework, and I agree again that in Europe, and guess what, Britain's actually in Europe. Not everybody likes it, and we sort of float around in the English Channel a little bit, but we are actually, in legal terms, thank goodness, for the time being at least, until our Prime Minister takes us out, or some future Prime Minister takes us out, part of the European Convention framework. And that's been very, very important, I think, to our recent discourse and protection of religious freedom and of equal treatment. I so agree with that. I think that in addition to being part of the convention in the United Kingdom, we've actually got a very interesting and important tradition in the UK of rubbing along together. I would rather be a Chakrabarti in London than in Lisbon or in Paris or in Louisiana, dare I say it, than lots of places in the world. I do think we've got a pretty decent tradition of rubbing along together and not making too many windows into each other's consciences. And that was my Elizabethan moment. It won't last. I'm not an academic. And I think that the convention can complement that. And I think that the United Kingdom's sort of recent years of coping with post-imperial migration and of settling some of these difficult rubbing points has a lot to contribute to continental Europe, if I may say so, where sometimes too many lines are put in the sand, and are you French or are you a Muslim, in really quite an unhealthy way. But we, in turn, can learn from the convention, and we can animate it and its jurisprudence with some positive parts of our multicultural tradition. So briefly, what do I think the answer is? Well, Chakrabarti on religion goes like this. Don't worry, it's short because I'm not an academic. They're going to sort it all out after we kind of throw it all in the air, as you've been told. Chakrabarti on religion, 3 choices. I may be a civil libertarian, but now we're going to be very prescriptive. You have 3 choices, not 4.5, not 19, but 3 choices as to how to cope with this thing called religion in a modern human rights respecting society. Proposition number 1, pick your favourite one. Anyone, just pick it. Choose this particular belief system and elevate it above all others and entrench it into your legal norms, your cultural norms, all the institutions of the state, and this is it, and everyone has to subscribe to it. Extreme example, I guess, is Afghanistan under the Taliban, but other examples might include my own country, the United Kingdom, at earlier stages in its history. That's the first choice. Second choice is sort of the opposite, the equal and opposite. Let's just be clear, this is all dangerous, divisive, mumbo-jumbo, this religion stuff. No good can come of it. No good can come of it. It's all inquisitions and jihads, and it's never the Sistine Chapel or Mozart's Requiem. It's never an act of kindness or charity, so we don't like it. And so if we can't ban it, we will chase it from the public sphere into the private sphere, upstairs, in the bedroom, under the bed, with the pornography. That's it. We don't do religion in the public space. Extreme example, I guess, Stalin's Russia, and more recent example, I'm going to enjoy this, the French Republic, with all that hideous burqa stuff, which is absolutely disgraceful. And the logic that says that you free even an oppressed woman by criminalising her is extraordinary to me. And we have this debate every so often in Britain, and it's a thinly veiled, pardon the pun, racism, masquerading as feminism. Because when I do see a woman covered from head to toe, of course my feminist heart doesn't leap with joy. But we have newspapers back home where you see women with their breasts bared on page 3, and people look at that, including children, over their cornflakes, and my feminist heart doesn't leap with joy at that either. And then you get into all the debates about who's choosing it and is there ever an active choice. But burqa bans, take the proposition that a woman has been forced, take the proposition that sometimes under that burqa there are bruises. How are we going to liberate that woman? By making sure that she can't walk the streets, that she can't go to university, that she can't be exposed to other women's discourse and encouragement and solidarity. Extraordinary. And so there is a case pending in the Court of Human Rights, and Liberty doesn't normally interfere in other countries, but we're feeling a little bit imperialist about that one. It's the French after all. So we're intervening in that case because we don't think that is a good way to express liberal human rights values. And the third proposition, you can get from this caricature that I don't really agree with propositions 1 or 2. I didn't do a very good job at putting these neutrally. That's why I'm not an academic. So the third option that we're grappling for at Liberty is something that we consider to be a more human rights friendly approach to this tension sometimes between religious freedom and other very important values like equal treatment in the modern world. And I think this is one that has to recognise that human beings are creatures of faith and logic, emotion and reason. Whether you are religious or not, you will have made all sorts of very important judgments and decisions in your life based on things other than algorithms and purely logical decisions. Who you kind of took a shine to when you walked in for breakfast this morning, and who you instinctively felt a little more suspicious of. Sometimes people get married on that kind of basis. You know, they vote on the basis whether they like the cut of someone's jib. That's an English thing. Don't worry about it. And that's just the reality. And yes, science has been responsible for great things. Penicillin, and it goes on and on and on. But also scientists and engineers built the gas chambers because those bullets were costing too much. And yes, religion can be dangerous and divisive in certain versions because human beings can be that way. But it can also be responsible for, as I say, Mozart's Requiem and great acts of kindness. So we are grappling towards a view of the world where religion should have neither privilege nor punished status, where people under Article 9 of the Convention on Human Rights have the right to the faith of their choice, have crucially the right to no faith at all. And of course we know there are countries where that is not the case. But perhaps most importantly of all, have the right to be a heretic in any faith community, because I think it's through that heresy, not a lot of people remember this, but I'm told that even Jesus was prosecuted for blasphemy. That was what he was crucified for. Did you know that? Anyway, it's heretics who sometimes move the discourse within a faith community. It's the gay Muslims and Christians. It's the woman the Sikh woman in my own country who wrote a play called Beshti, or Shame, about sexism and misogyny in her own community, and that play got shut down by the mob and the police did nothing to protect it. Sometimes the heretics inside faith communities who will take this discourse on and help with the human rights animation. And so on that basis, and I am going to stop because I've had my 10 minutes, we intervened in some of these important cases on the workplace and on clothing and on these various negotiations in the Court of Human Rights. And we think that in the recent judgments, in the cases of Awida, which was the British Airways worker who wore the small cross and wasn't hurting anybody, wasn't discriminating, wasn't hampering the delivery of services, wasn't compromising security or health and safety, was just wearing a cross. Our courts, our domestic courts, got that case completely wrong. And they said that it wasn't discrimination because she couldn't demonstrate that lots of Christians wear crosses or that it's somehow a theological requirement. So what? Who cares? If one woman chooses to wear a cross and it's not hurting anybody else, I agree with, I think, the sentiment of the professor earlier, that it's her faith is her faith, and that's a human rights perspective as opposed to an old school 1970s kind of lefty group theory perspective. Our courts got it wrong. The Court of Human Rights in Strasbourg got it right, and I'm so glad they did, because the burqa cases are coming. And sometimes you have to get into these debates and look at this litigation with a view to what's coming next. Contrast that with the cases on the delivery of services. Lillian Ledeli, the registrar who refused to do civil partnerships even when the law changed. I think that's difficult, and we, I'm afraid, do equate that with someone who wouldn't marry people of different races. That's where the settlement has got, and I think there does come a point when the conscientious objector has to leave the military. But in all of these cases, we accepted and intervened on the basis that there was a right engaged. Even though we didn't agree with the way that everybody chose to discharge their right, there is a right of thought, conscience and religion engaged, and you interfere carefully, very carefully indeed, and only when it's necessary and proportionate for the rights and freedoms of others. Thanks very much.
Thanks very much. Next we'll hear from Hagai.
Hi, hi. Good morning. Thank you for the opportunity to speak here. When thinking about my remarks this morning, I was thinking of perhaps what could be expected given some aspects of my personal background, my professional background, the country that I come from. So perhaps it would be expected that I would choose to talk about being secular, secular Israeli, to talk about the issue of marriage in my country, a place where only religious marriages are possible to date. And being, in my past, a gay activist, in my present, still just gay, so somewhat less of an activist in that context, maybe to talk about some of the lessons from the struggle for pride in the city of Jerusalem, probably the most meaningful experience in my life to date. And perhaps in the professional context, being the director of ACRI in the past 5 years, coming from Israel, a state that has no separation of, well, synagogue and state, and where the trajectory looking forward perhaps is even of further enshrining in a legal fashion the Jewish identity, whatever people mean in that and whatever people read into that of the state. But I wish not to talk about any of these issues, and I wish to pursue a different course this morning. And also, following what Professor Anaim said earlier, I hope that you will find these statements to be thoughtful and thought-provoking, and obviously there's no desire by my side to offend anyone. The title for the panel, Religious Freedom, Expressing Religion, Attire, and Public Spaces, it made me, again, hearing that title and thinking about Israel, what about Women of the Wall? What about sitting at the back of the bus? And so on. But that's usually the direct context in which public spaces and the intersection between religion and human rights are expressed in Israel. But let's take this somewhere else. And when thinking of public spaces, let's think, for instance, for a moment about the room that we're in, and how much religious attire are we seeing in this room, and what does that express? Now, obviously, there is the possibility that there are many closeted people of faith in the room, that people have stepped out of their burqas down on the street, or hid their yarmulkes or the crosses, perhaps in a way already living the potential future legislation that's suggested in Quebec, or the trajectory that some European countries are following. So that is a possibility, but again, as a gay individual that has a long relationship with the closet, then I think we all are familiar with the liberal and post-liberal critique of that idea. So even if that is the case, and I guess we all probably share my assumption that that's probably not the case, at least for most of us in this room, even if that was the case, then that would have been very problematic in and by itself. And obviously when thinking not only about the people in this room, but also about the organizations that we come from, and also the organization that I come from. We are also, in a sense, a public space, and certainly desiring to talk on behalf of public values, broad values, the values of the public, to represent the public good, and so on. So I wanted to talk about that context, which is more intimate and more close and more direct, and turn the spotlight from those external public spaces to the public spaces that we occupy. And in a way, and again reflecting on what the keynote speaker was discussing earlier, about changing the power dynamics not outside, but changing the power dynamics inside in our organizations, and what is the relation between that and our ability to be effective vehicles for change and for good in whatever way we understand that. So my original plan of presenting that was by invoking a recent case in Tel Aviv, which was about the opening or closure of stores on Shabbat, on the Jewish weekend. There was a city of Tel Aviv ordinance that made that illegal, but what the city used to do was not to enforce that, but rather fine the stores that were open on Shabbat. So the city got more income through these fines, and the stores remained open. The law was violated, and that was the status quo for quite a few years in Tel Aviv, the city where I live in, until someone petitioned against that. You perhaps would be surprised it wasn't a petition submitted by Orthodox Jews, but rather a petition submitted by the owners of small shops in Tel Aviv that actually wanted the weekend off and couldn't compete with the big chains that were open. And eventually the court ordered the city to either change its bylaws or implement them. Now that was sufficient for Haaretz, the liberal paper in Israel, to come out with a full page, front page headline. Court orders closure of stores in Shabbat in Tel Aviv. Tel Aviv also being the symbolic, progressive, liberal, open city in Israel, as if this is somehow the introduction of Sharia law over Tel Aviv and the death of liberal Israel in some form or another. And my plan was to take some time and pause on that and explore the knee-jerk reaction in that context, and ask, really, is that really the way that we should respond to that situation? Doesn't it invoke other questions? Isn't it perhaps an opportunity for us to have a different conversation about the way we want to handle our public spaces? What about the rights of employees that will have to work on the weekend, and how these will be defended in a country where there's a legacy and a reality of broad violations of workers' rights, and so on and so forth. But I'm not going to discuss that because earlier this week, Rabbi Ovadia Yosef passed away. And you may have seen this picture on, again, referring to another newspaper, this time the New York Times, a front page, above the fold picture of the funeral procession in Jerusalem just a few days ago, with some 700,000 participants in the funeral, probably the largest public event since the establishment of the state. Obviously, often Israel does make front page headlines. I don't remember when recently did that happen in such a context. Not the conflict, not the occupation, and so on, but rather that. A very different picture of Israel in the front page, above the fold. Rabbi Yosef, maybe I'll say a few words about him. Certainly, there are at least two, not pretending to be a scholar of his life, but at least two key things that I thought I must mention in the context of his life and his work. One is, in a country where Ashkenazi Jewish privilege and discrimination against Mizrahi Jews has been the reality for many years and still is in a variety of ways. Rabbi Yosef and the party that he created, the political party that he created, Shas, have been the vehicle for beginning conversation and making a huge difference in that regard. And when you think about our work for equality and against discrimination, also in the internal Jewish context between Ashkenazi and Mizrahi Jews, Jews of European origin and Jews of non-European origin, then maybe we should have done that, right? But I think it's a fair assessment that if Mizrahi Jews would have been waiting for liberal human rights organizations in Israel to carry that burden, then they would still be waiting. Now, obviously, a lot of us have plenty of criticism with regard to Shas, and I'll talk about that in a second. But we certainly didn't deliver in that regard. And we have our justified critique with regard to those that have delivered, at least to some extent. And the other thing that should be said is that in many of his religious decisions, while remaining within Jewish Orthodox law, remaining within halakha, he was one of the most progressive of Jewish scholars in a variety of issues. Now, obviously, at the same time, Rabbi Yosef, in his life, has also made terrible statements on gay rights and on other issues. And the party that he created, Shas, the Minister of Interior from Shas, this is just one example, under the previous government, was there, in many ways leading the charge against asylum seekers in Israel, portraying them in terrible ways, wishing to make their lives as unbearable as possible so that no additional asylum seekers would come into Israel, and eventually passing one of the most terrible laws in Israel's history, the anti-infiltration law, that basically sent asylum seekers to administrative detention periods of no less than 3 years. And obviously I'm so proud that through a petition submitted recently, decided recently, but submitted by ACRI and others, the High Court turned that recently. So when we have criticism of Shas, that's very justified as well. And the picture and the reality, obviously, in that context is very complex. But what I did want to share with you today is just a nugget of our recent interaction with that event that I've shared with you. And the story unfolds in the following way, and I think it's very telling in a very deep sense. And someone published a post on Facebook after Rabbi Yosef's death, in which he equated him to Hitler. Obviously, people were offended by that. Someone complained to the police, and they were so proud of their ability to identify the individual behind those statements. They contacted him, demanded that he would take off the offensive post out of his Facebook feed. He refused initially. This is according to the police's record, suggesting that he may have some freedom of speech rights. They didn't accept that. And not only that they're investigating the case, but the individual happened to be a soldier in the IDF, so if I understand correctly, the entire set of details, it's also be explored by the military police. An individual will be sent or is already serving a 30 days sentence on his army base. Now, obviously, this was brought to our attention, and we intervened very quickly, as we would and as we should in such a case, on behalf of freedom of speech. It is very offensive to many people, but obviously this is a statement that is absolutely legal and acceptable. And we intervened very effectively and very quickly with the national police and with military police and so on. Okay, that's the story. Now I want us to take 2 steps back and just reflect for a moment on it, and with that I will conclude. Eventually, the only statement that the public will see with regard to what ACRI has to say, the only thing that we have to say, even remotely related to the context of the funeral and the passing of a great leader, of a huge part of Israeli society, is that statement. Acri to the police, it is okay to equate the late Rabbi Yosef to Hitler. And it is obviously not surprising to make the assumption that a lot of people that are going to read that are not going to become more fond of Acri or of human rights or of freedom of speech. And that's the only statement that we're going to have out there in that context. Now, if we had a lot of other statements that would somehow relate to non-Ashkenazi Jews in a way that relates directly to issues that are of concern to that huge community in Israel, then the picture would be also more complex on our side. And obviously, we also do a lot of that work, but I don't want to run into that direction and remain in the critical spot and reflect about the connection that exists between who we are and what we do. Who is on our staff and what is on our mind, and who has access and who has privilege, and what is the power dynamics that eventually, internally in our organization, that eventually creates this sort of reality that plays itself out. This was a very specifically dramatic occasion, but also plays itself out in a similar fashion, well, basically over the past 40-something years of the history of the organization since it was established in 1972. And the question of how far can we be from the public in our own demographics, and how far we are from the public in our values, these are questions, and to what extent that can be the case for decades, and for us to imagine that with that context we will somehow be successful, and that the vast majority of Israelis, not the court, the vast majority of Israelis will share our values and want the kind of future that we want for Israeli society, that is a difficult and hard question that we shouldn't dodge. And it all goes back to that question of the internal power dynamics in the organization. And with that, I'll pause. Thanks.
Sure. Hassan, Baghdad, and then we'll have some discussion.
Thank you. Thank you very much. I thank the organizers, and I'm very pleased to be on this panel with also fellow members of the International Network of Civil Liberties Organizations, whose launch took place yesterday, and we see this conference also as our first sort of public outing on this theme, which is hopefully going to be one of the three themes that our 10 organizations are going to be collaborating on in the next couple of years. We've identified issues that affect all of us in our work as national human rights organizations, in which we can share experiences, and religious freedom has been highlighted as one of them, in addition to informational rights and the policing of mass protests. And so from this practitioner's point of view, I would like to perhaps share with you a few observations, a few lessons we learned from our work on defending cases of religious attire discrimination in Egypt and before Egyptian courts, mostly related to the full face cover or the niqab in Egypt. My organization started to work on issues of religious freedom as part of its privacy program. So when we started 10 years ago, we did not have a standalone team working on religious freedom and sectarian violence as we do right now. But we were interested in defending the right to privacy. And very quickly we started to see the trend of violations of the right to make one's private religious choices as a repeating pattern, but also we started to see how both the state authorities and other authorities that are the authors of these discriminatory practices and the courts that sometimes sanction or legitimize or accept these acts of discrimination use pretty much the same reasoning. And so the big enemy, it turned out after years of litigating cases ranging from defending university students that are barred from using public university dorms if they wear the niqab, or sitting for the exam unless they accept to remove the niqab for the entire 3 hours of the exam, not just at the beginning of the exam for identity checks as used to be the case, or defending unrecognized religious communities like the Baha'is in Egypt, who in 2004 were asked to either forego the rights to obtain necessary and mandatory identity cards, or choose one of the 3 recognized religions of Islam, Christianity, and Judaism. And without an identity card, of course, one has absolutely no access to any services in Egypt. It's a state of civil death. The third set of cases that are related were cases of conversion from Islam to another religion. Most commonly, it is Christians that convert to Islam briefly and then seek to convert back to Christianity because the Coptic Orthodox Church in Egypt has a very restrictive position on divorce and second marriage, and so many thousands of particularly Christian women, but also men, are really stuck in very unhappy marriages. And what they do is they get a court order divorcing them as Muslims. They convert briefly to Islam, and then they seek to convert back to Christianity in order to marry another Christian person. And of course, that the state realized that this phenomenon was happening, and the church was unhappy, and as a result, there were hundreds of cases before the administrative courts of people that have gone half the way and were stopped basically from reconverting back to their faith. In all these 3 types of cases, the religious attire, the Baha'is as an unrecognized faith, and conversion from Islam, so we'll call them the apostasy cases as our courts do. The one enemy is public order. It is not Sharia. It is not Islamic law, and the justification really in order to rationalize the discrimination and the abuse, both the state and courts resort to the use of public order as a way to effectively trump any constitutional or legal protections for religious freedom or privacy or protection from discrimination. And the reason is that Egyptian law is a hybrid body of both with some Islamic elements but also secular or non-religious elements. The most commanding and the most the best known Islamic provision is the article in the Constitution that says that Islam is the official state of the official religion of the state, and Islamic Sharia is the principal source of legislation. Because it's a source of legislation, it's been interpreted over the years by the Supreme Constitutional Court as a directive for lawmakers, for the legislature, when they're writing new laws, that they cannot write laws against Sharia, against Islamic law. And so when these university students that have been denied housing or denied the right to sit for the exams, as well as Baha'i kids that have been thrown out of school because they don't have a birth certificate, because mentioning religion is mandatory there, or of course women fighting for custody of their children because they are on paper Muslim, but are in reality Christian and are fighting a husband of a different faith. In all of these cases, the courts cannot really find a justification in the Constitution or in laws for these abuses. And yet, the court, of course, is not willing, in many cases, to go as far as saying, well, the law actually has nothing on recognized religions. There's absolutely nothing in the legal body in Egypt that says there are only 3 religions and the state should recognize the Baha'i faith, or that even if you don't recognize it as a faith, the state should not force people to lie in their official identity documents about their true religion. The fallback, the favorite fallback for all of these courts is using the notion of public order, which unfortunately is a concept in international law very ill-defined and confusing, and another thing inflicted upon us by the French and still with us, and it has been migrated in many domestic laws in terms of ordre public, of course, not public order as in law and order as it is known in the Anglo-Saxon word. Unfortunately, it has become for us this legal monster that is often open to different interpretations, depending, of course, on the religious bias of the judge, the religious bias of the state, the majority-minority power dynamics in terms of religion, and who is in power. So, of course, these Niqabi students were a persecuted community under Mubarak. During the Muslim Brotherhood rule, there were absolutely no moves against them. They enjoyed all the rights. Now, of course, any form of a beard or a niqab is cause for discrimination and harassment on the streets as part of the new military war on terror that we are living in Egypt nowadays, and as a result, this definition of what is public order being the fundamental nature of the state, the founding principles of society, blah blah blah, all these meaningless statements about our society is having some true and static and everlasting and evergreen fundamental nature, and that unfortunately has been incorporated in many of the problematic rulings of the European Court of Human Rights, also on religious attire, on the niqab, that there are principles that are part of the founding nature of society that should be left to define by states as part of their margin of appreciation, most notably, of course, in the Turkish niqab cases. The other tool, in addition to public order, I mean, this was really a call for action. I've been for years arguing that, as a community of human rights practitioners and people interested in religious law, something needs to be done about how public order is defined as a permissible limitation on the exercise of the right to freedom of religion, but it's also a permissible limitation on a bunch of other rights, and it doesn't just affect the area of religion, but also gender and sexuality in particular. The second tool that's been used by the state is to say, but this is not religion, and therefore this is not protected. And that's something that is a recurrent practice, of course, and an easy recourse also for judges in cases where they want to sanction discrimination. That, of course, was clearest in the case of the Baha'is. Anything that happened after Muhammad cannot be called religion. So while we are willing to accept that there were prophets before him, since in Islam we believe that he is the last prophet, how can anyone come afterwards and say, I have a new prophet, or I have a new faith, or there's been another revelation, and that of course is a major issue for the Ahmadiyya community around the world, because they believe in a revelation after Muhammad, but also in Egypt it affects primarily the Baha'is, because they who incidentally believe in all three religions, but believe that they are the fourth Abrahamic faith, if you want. And so the state and the courts found it very easy to say this is an ideology, and religious freedom only applies to religions, and the protection of belief only applies to religious belief, but this is an ideological belief. The same happened with the niqab cases. In all of them, the first thing that the state's lawyers would do arguing these cases against us is to go to the mufti, the state official religious advisor, or go to Al-Azhar and get a fatwa and present it to the court that says it is not mandatory in Islam for women to cover their faces. That it happened in every single case. It got so boring at a certain point, because they keep making exactly the same argument, and the courts keep saying, yes, we understand it's mandatory, but is it discouraged by Islam? Unfortunately, you have to fight only on religious grounds before courts, and we were always pushing courts to say, never mind whether it's mandatory or discouraged. The state has no right to impose its own interpretation of Islam. But again, in most of these cases, if it's not public order, then the easy tool is to remove the contested practice, whether it's the faith or a religious attire or religious practice, outside the narrow realm of protection of religious freedoms. These are just a couple of the issues that we have come across, but I look forward to these 2 days of discussion when we're going to come back, I'm sure, to many of these issues. Thanks.
Thank you so much. We're operating with a different definition of 10 minutes than you usually do, and I'm going to continue that tradition just so we can have a few minutes of discussion. And I'm going to sort of ask the first question and try to draw a connection between some of the comments that have been made, because the tension that Abdullah Ahmad An-Naim sort of described in the keynote address between kind of anti-imperialism and yet like a universality to human rights, I think has continued through this discussion. And I just want to draw out that theme and ask people, just challenge people a little bit to articulate their view on this, because the headscarf and niqab and burqa controversies bring this to the fore, right? The claim on the part of the French government when it instituted the ban on headscarves in French public schools was, of course, this is anti-imperialist. What we're doing is helping women internal to these religious communities who want to claim, self-determination, right, which is Abdullah An-Naim's sort of key value. We want to allow their self-determination by fighting imposition, of the veil. This is an anti-imperialist strategy, and yet, Shami Chakrabarti sort of used sort of said, well, actually, we're going to sort of try to exercise some imperialism against France, right? So we're going to impose on France our view of what it means to protect individual liberty, and that is to allow girls who want to wear the headscarf in public places and to do so. So there are competing notions of imperialism, right? But But I guess my question is, why not embrace, whatever vision, moral vision we have of the proper balance between kind of religious freedom and equality norms, and then impose that, including with coercive mechanisms implemented by legal regimes, because we think it's right. And so why isn't that the sort of proper approach to take if we're sort of human rights kind of advocates in this field? And then we can have a discussion about which is the proper, imperialist mode. That is, what is the moral content of the imperialism we want to impose using coercive means?
You've got to let me come back on it. This doesn't work. It's a French microphone, and it's been. I was kind of being a little sarcastic before when I talked about our imperialist intervention into French public affairs. The reason why we as Liberty, a UK NGO, have stepped into that litigation is because it's not just about France. This debate is happening in our own country. This debate is happening all over Europe, and we think it's incredibly toxic. And we don't think that it sits well with the liberal, progressive, human rights tradition to tell people what they should wear, and to do so under pain of criminal sanction. And I think, we have to be true to our values, even when people wear things and say things and do things that we don't like. Otherwise, we look like hypocrites. And I'm sorry, I just take whether it's about clothing or whether it's about interrogation techniques. Some great democracies over the last decade have let themselves down and not been true to the human rights values that they have been espousing for other people all over the world, and that is why it matters. And as I said before, I come from a particular tradition, including a feminist tradition. My heart does not leap with joy when I see a woman in a sack, but nor does it leap with joy when Mr. Murdoch's most popular daily newspaper in my country shows women with their breasts on page 3. But nobody's, the people on the right of politics in our country who are now talking about burqa bans are not talking about page 3 bans, because freedom must reign, because people must make choices. And I would also say on a personal level that, because of my work and because of the events of the last decade, I have now spoken in many mosques. I have spoken to audiences of men and women in mosques. I have spoken to audiences that have included mothers and daughters, where the daughter is dressed in more religious garb than the mother, and some of that is a political response to the war in Iraq and all sorts of things. So I can't make the assumption that every woman has been forced. And we just don't tell people what to wear unless there is a necessary and proportionate justification, such as the need to, health and safety. If I'm wearing my crucifix while I'm performing brain surgery, I think our wonderful National Health Service is allowed to tell me that is not sanitary, and that is not a good thing to do in the operating theatre. Equally, if I'm covering my face at the border, it may be legitimate and proportionate to ask me to go behind a screen and to identify myself to a woman, just as I can be subject to a body search. But we don't just ban people's clothing because we don't understand it or like it. This stuff wasn't designed to make us comfortable. This human rights stuff was designed to keep us free.
Okay. Mark Kelly.
Yes, just to mix things up maybe a little bit. I'm always tempted to engage with Shami when Shami starts to talk about France and the French model. I lived there for about 12 years, and the
wine is very good.
The Francophile, the Francophile in me awakens always when I hear Shami speak on this subject. My own reflection would be that just as our keynote speaker made the point that there never really has been an Islamic state, I think it's also fair to say, if you look closely, that there's never really been a secular state either. In all of our states, in different ways, religion is very much at play, and it becomes a regulating factor in people's lives. to an excessive extent if you're not very careful, as in my own country, the Irish Republic, which I'm going to be talking about tomorrow. But specifically where this is concerned, if we reduce it, I think, as human rights lawyers or advocates, just to this question of whether or not it is legitimate to become involved in telling people what they can wear and not wear. If we look at it only through that lens, I think if we bring it back to France, the problem from a French perspective is that an effort is being made, and I agree with you, actually, it's a misguided one, I'll give that away, but an effort is being made to control a problem which is also a real problem, which is that in a significant number of cases, it is men who are telling women what to wear. So I just want to throw back those two things. Firstly, Shami and I are used to talking over each other, so don't worry about it. Firstly, it's not just it is the challenge for a state that professes to be a secular one or has that as its ambition, precisely as our keynote speaker was suggesting, in order to create or open up a space for religious freedom and religious expression. What do you do when you actually suspect that repression is taking place, and in particular that repression may be taking the form of forcible compulsory wearing of the niqab or the hijab? What should human rights advocates do to rise to that challenge?
Just briefly, because it's boring for other people, and we will continue this, Mark. I know. You don't respond with wrong-headed, counterproductive, repressive measures that will actually imprison the women that you say you're trying to liberate. How on earth is it progressive or feminist to say to those young women, whether they're being forced or not, you now can't go to university. You now can't rub along with the women that would help empower you and nurture you. This is and I have to say, I don't even agree that this policy has been adopted in good faith. I know that you're having this debate in good faith, but I don't believe that President Sarkozy adopted this as a feminist measure. I'm sorry, but I don't believe it. I think it was courting Front National votes, just as some of the rhetoric that comes out of my country at the moment is about courting UKIP. So I never doubt your good faith, Mark, but I do doubt the good faith of some populist politicians who are suddenly so feminist. You know, it is not great to be non-white in Paris and to be a French Muslim. It is not a great place to be. I've spoken to some of these kids. They're being asked to choose between two parts of themselves. That is not something that you want to do to people lightly, because multiple identity is not some fancy bourgeois liberal construct. It is the reality of the human experience. Don't tear people apart and make them choose. When that happens, it is a recipe not for cohesion but for conflict.
I'm not bored by this. In fact, it's. I mean, these are the kinds of debates we had all the time before the revolution in Egypt, and it's sort of refreshing to not be talking about the political situation in Egypt and go back to these debates. It was very controversial when we did it. When we took on the cases of the niqab, even though this was between 2005 and 2009, when there was no threat of Islamists taking over the state and turning it into a religious state, etc. So people were much more cool-headed even then than they are right now about whether or not by defending these university students we were supporting the project to Islamize the state. But of course the colleagues from an older generation of the feminist movement, and some in the human rights community and some in the secular community, felt we were either being naive in taking on these cases, or that we were being instrumentalized as part of the Islamist project. The answer for us was, I mean, the way we made this decision was straightforward. One, we, of course, the number one reason was to support these university students. That, I mean, the students that wear the niqab, for the most part, come from poorer provinces in the country, and these are the students that need public university housing the most because they are from out of town, and denying them state-subsidized housing and meals in order to empower them, but really in order to protect the universities as beacons of liberal education that we don't even get, and was for us very troubling, and we needed to support these women. From again a human rights practitioner's perspective, it was there was also a tactical benefit for us. We needed to make the case that these protections were not just working for pornographic scenes in films and daring novels and Baha'i aliens and people that want to leave the faith, etc. We wanted to make the case that these protections are there also to protect the majority or faiths within the majority, and they are for everyone. And we, even though we are Western-funded, elitist, Cairo-based organizations, that we were willing to also take on these cases, and that was important because the courts, incidentally, was considering both issues at the same time. It was the same court looking into the niqab and the Baha'is in the same time period, and we were the same people arguing the cases in front of them, and that was important for media and for the courts to see. The freedom of religion and belief precedents that we were trying to set in these cases where the judges were going to be more sympathetic. The judges finally found for the students, obviously, and against the universities. I forgot to mention. And these precedents, we wanted to get these precedents to apply them to less popular, less sympathetic communities afterwards, and to apply them to everyone. And finally, we wanted to get some language, but also public opinion, more importantly, and that's how we use courts in Egypt and elsewhere to say that the state should stay away from women's clothes and should not be interfering with this, because we knew that there would be a time when we're going to be on the other aisle fighting for women that are actually resisting the imposition of a certain uniform on them. We're not there yet. The concern of women being forced to dress in a certain way is a concern that many of my colleagues had. But what about women that did not choose to wear the niqab and maybe are hoping that the universities would adopt this policy? So the answer is these women. If universities are allowed to pass these policies and these policies stand, these women are going to switch to Al-Azhar for religious girls-only education, or they're not going to go to university to start with. They're not going to lift I don't know about France. I can talk about the Egyptian experience, but they're not. I mean, it's a very urban, if I may say, concern in Egypt, because in Egypt, you can, in Cairo, you can really spend days and days and maybe see one or two women wearing it. But there are entire villages where, there's only one woman who shows her face, maybe, and there are. The debate that is taking place around these issues in Cairo, in the national media, and in Cairo courtrooms is not reflective of really the state of the country as a whole, and especially the more provincial and tribal and poorer communities. Yes, I do agree there needs to be protections, and that's why in Egypt, the court actually supported a decision by the Minister of Interior to prevent pre-university students, girl students, from wearing the full face, because that's under child under the child law, and the courts did not have an issue with this. It went to the Supreme Constitutional Court, and it supported the policy, etc. So I am willing to accommodate, of course, protections for young girls against extreme restrictive interpretations of religion or religious practices that are harmful. But I don't think that I agree with Shami that the debate is really about modernizing societies, not about quote unquote modernizing our societies, and not about protecting our children and women.
So people want to take a break, but why don't we do this way? There's a couple of people who want to ask questions, but I do want to take a break. So why don't we have a question from Susanna Mancini and a question from Eva Brems, and then no answers, and we'll go right to a break. Okay? So we'll just collect the questions without answers, and then we'll take a break.
Okay, thank you. So I totally agree on the bad faith of the debate, and especially I think that the use of feminist rhetoric and feminist language and measures restricting the right to wear certain clothing is a misuse. I suspect that there is somehow a phenomenon of false projection. It's a matter of projecting onto the Oriental other misogyny, patriarchy, etc., etc. So Islam ends up by being constructed as the patriarchal one, which is a wonderful way to somehow get rid of a number of unresolved problems within Western societies. I also do not agree that women are forced into wearing, at least in Europe, into wearing Muslim clothing, but I think Eva, who's conducted great empirical work, can actually enlighten us on this one. Even if they were, I don't think this is the business of the state, because women, irrespective of where they come from, social groups, religious groups, undergo tremendous pressure to dress one way or the other in Western societies. But having said all that, I really do not agree that this isn't a French problem. The French do it their way because they use the law, which has a certain meaning within their constitutional and cultural tradition. This is really a European problem. It's no good to be a Muslim in Europe, irrespective of where you are. Legally speaking, the problem is that there is an increasing blurring between what is an inimical political ideology and what is a religion, which leads to an invidious scrutiny by courts. This is, I think, the problem. It's a matter of trying to protect our societies from values assumedly represented by Muslim clothing that are felt to be a threat. This is what we should focus on.
Yeah, indeed, I was going to react to your comment, like the majority of these women are being forced to cover their face. Where does that come from? I can imagine young girls wearing the hijab, yes, many are told by their parents to wear a hijab. But adult women wearing the niqab, there is now empirical research in 5 countries, in the UK, in France, in Denmark, in the Netherlands, in Belgium. None of us, we did the research in Belgium, has found evidence of women being forced to wear. I know it's a small country. We really looked for that because it went against my own feeling or whatever idea I had before I started the research. I think surely there will be many who are forced. But so it's a small country. You talk to the social workers who would have found cases. We found no evidence. So nobody can prove either that there are no women being forced to wear it. There may be. Maybe there are some, but then, the other arguments apply. The Belgian law, contrary to the French one, does not even provide a punishment for the person who would force a person to cover herself. It provides only a punishment for the woman herself. Yeah.
Well, this is terrific. So let's take a real 10-minute break, and then we'll come back. We're delighted to have 3 distinguished academic commentators today. To give their reflections on this set of issues. The first will be Eva Brems from the Human Rights Center at Ghent University. She studied law at the universities of Namur, Leuven, and Harvard. And before joining Ghent University, she was a lecturer at Maastricht University in the Netherlands. Her research interests include most areas of human rights law at the national, European, and international levels, with a particular emphasis on cross-cutting themes and diversity-related issues. She is the author, among a great many other works of uncovering French and Belgian face covering bans, which she published and co-authored with other people and published in 2013, just this year, and doing minority justice through procedural fairness, face bans in Europe, also 2013. After her, we'll hear from Alejandro Lajus from CIDE. He teaches in Mexico City. And he has an LLM and a JSD from Yale, as well as an undergraduate degree from Mexican University. He heads the Right to Health program at CIDE, and before becoming a full professor in 2009, he practiced constitutional litigation, specializing in high-impact public interest cases before the Mexico Supreme Court, most notably on abortion law, same-sex marriage, tobacco control, and telecommunications law. Finally, we'll hear from Lucy Vickers from Oxford Brookes University. She's in the law department there. Her main research area is the protection of human rights within the workplace and aspects of equality law that relates to that issue. She's written extensively on issues related to religious discrimination at work and age discrimination. She's the author of Freedom of Speech and Employment from Oxford University Press in 2002, as well as Religious Freedom, Religious Discrimination, and the Workplace from 2008. Please welcome all of our panelists. We'll hear first from Eva Brems.
Okay, thank you, Nelson. So I'll talk more about the face field bans issue. Starting point is there is this trend in many European countries to ban face covering in the public space. So targeting, in fact, women who wear the Islamic face field. It started with municipal bans. Such municipal bans, local bans, are in place today in Belgium, in the Netherlands, in Italy, and in Spain. And at a regional level, a ban was just voted in by referendum in Ticino in Switzerland a few weeks ago. At the nationwide, bans have been adopted in France in 2010, in Belgium in 2011, and proposals for similar nationwide bans have been dismissed, for now at least, in Denmark, the Netherlands, Spain, and Switzerland, while a proposal remains pending in Italy. Now, an important fact that has been mentioned already is that a challenge to such bans is currently pending before a Grand Chamber of the European Court of Human Rights, the case known as SAS versus France. There have been numerous third-party interventions there by Liberty, by Amnesty, by Open Society, and by us, Human Rights Center at Ghent University. Now, one of the things we and Open Society did is to bring in empirical data in our third-party intervention, because one of the most remarkable aspects pertaining to these burqa bans and the debates is the fact that they proceed on the basis of assumptions about women wearing a face field that lack any basis in knowledge. So at the time the bans in Belgium and France were adopted, there was no empirical research available that would document the experiences, the motives of these women in those countries. Nor was any effort undertaken to get to know anything about it, to consult these women in the process leading up to the ban, with the exception of one woman in the French Guérin Commission who asked herself, who sort of imposed herself as an interviewee. But today, such research exists, as I just mentioned, for no less than 5 countries: France, Belgium, the Netherlands, the UK, and Denmark. So what I want to do today is to sort of assess the chances of this case in Strasbourg, the SAS case, arguing that the crucial variable, in my opinion, is whether the court will be willing to take this empirical reality seriously that goes so much against preconceptions that everyone seems to hold. So in the case, numerous provisions of the European Court of Human Rights have been invoked. My guess is that the court will dismiss the Article 3 and Article 11 claims and will examine the case under Article 9, religious freedom, and then stating that the same reasoning applies mutatis mutandis under Articles 8, private life, and 10, expression. What I do hope, though, is that the court will address separately the discrimination claim, discrimination on grounds of sex, religion, and ethnicity, because the face field bans are such manifest examples of the adoption of seemingly neutral legislation that is, in fact, targeting a specific group, namely Muslim women who wear a face field. So the European Court of Human Rights does recognize the concept of indirect discrimination, which does not require proof of discriminatory intent, but even if it were required in these cases, it would not be very hard to deliver, as the debates in the parliaments, in the society, in the media were all about what was called burqas, never mind the fact that not a single burqa has ever been spotted in Belgian territory. It's really about niqabs. So it was all about it. In Belgium, here's some Belgian cultural fact. In Belgium, the ban was adopted on the 6th of December when we celebrate St. Nicholas Day. So that's the day, I mean, you see people dressed like that going around everywhere. That's the day we adopt a law saying you cannot go around in public with an unrecognizable face. Now, when anyone points out this fact, like this is going to apply to other situations, to youth leaders dressing up like Smurfs and that sort of situation, you're simply ridiculed. Simply ridiculed. Hardly a pretense is even made that it might ever apply to anyone but Muslim women wearing a face veil. And indeed, the record of application of the bans shows that much. So how does this work in Strasbourg? So once an applicant has shown that there's a difference in treatment, the government would have to prove that this difference in treatment pursued a legitimate aim and did so in a proportionate manner. So at that point, the discrimination analysis joins the line of reasoning in the analysis under religious freedom, so under which an interference can be justified if it has a legal basis, a legitimate aim, and the most important criterion, proportionality between the measure and that aim. So whether it's discrimination or religious freedom, the reasoning will be more or less similar. So what kind of legitimate aim will the French government, or would the Belgian government for that matter, invoke in Strasbourg to justify the ban? We can derive that from the parliamentary debates leading up to these bans, and there you can distinguish three dominant themes, also in the Constitutional Court cases that have been discussed at the Constitutional Court in Belgium and the Constitutional Council in France. So there's public safety, there's women's rights, and there's social interaction as a matter of ordre public. Yeah, the French really reinvented their public order concept, introducing immaterial public order specifically for this. So I'll briefly examine them one by one. As Nelson gave me a limited number of minutes, I have on the slides a few quotes from interviews with niqabis so that we can introduce their voices in the debate, at least in that way. Now, first, this goal of uncovering in the name of public order that requires people to interact socially. So the idea being that everyone in public, in the public sphere, must be recognizable and available for communication with others. So the French ban relies very strongly on that argument, really turning it into a requirement of ordre public. Can this argument justify a general face covering ban? That seems highly questionable, for once, just because we can wonder whether a face veil really precludes communication in an age of telephones and that sort of things. Well, several among our interviewees expressed a self-image as very open and sociable persons. Many state that from their perspective, communication is perfectly possible, even if they recognize that there appears to be a communication barrier on the side of others. Now, what we see also is that within their familiar environments, especially, of course, before the ban, face veil wearers participated in a wide range of social activities involving contact with others. In shops, in schools, in administrative offices, simply with the neighbors, that sort of contacts. Also, several of the interviewees told stories of how a conversation with an initially suspicious or even aggressive stranger turned sometimes into a positive exchange, an actual encounter between people. Now, what did the ban do? It appears that the ban has not increased the social interactions by these women. In fact, many women who choose to wear the veil, they are very strongly attached to it. They feel very strongly about it. So they continue to wear it despite the ban, but they don't go out. Or they go out only by car because they fear the police, or they fear even more their fellow citizens. The research on France and Belgium shows that face veil wearers in these countries suffer serious harassment in public, and strongly suggests that such harassment has increased as a result of the bans, with many citizens behaving like a kind of vigilante police. So instead of increased social interaction, the effect for these women is a serious deterioration of their social life, of their interactions with society at large, and of their mobility. Research in France after the ban shows that women suffer in particular in their role as mothers, as they used to accompany their children to and from school, to and from their hobbies, something many have now given up. So even many women who stopped wearing the veil report a decrease of social interaction, as they feel uncomfortable in public without their face veil. So they also try to avoid this kind of situation. Even if there are some other women who, after taking off the veil, are more easily approached in the street by other people, so have more communication with others, even then, I think these empirical findings suggest that a ban is a disproportionate measure to achieve such an effect. And there I refer in particular to the narratives of positive exchanges that show that communication is a matter of goodwill on both sides, which is likely to be better realized by other than repressive means. What then about banning in the name of safety? Now, in the public discourse surrounding face veil bans, a safety argument often concerns subjective feelings of unsafety generated by the sight of a person who covers her face. In the Belgian parliament, for instance, the introduction of a face veil ban was compared to placing street lamps in a dark alley in order to reduce fear of crime and provide a feeling of security to the public. In our interviews, veiled women confirm experiences in which they engender feelings of unease or fear in others. At the same time, some of the women's stories also show that it is possible to overcome these feelings and to establish a normal type of contact. And such normal contacts appear to exist in particular with persons with whom there is regular interaction, such as neighbors, teachers, shopkeepers. So feelings of unsafety therefore do not necessarily accompany contacts with veiled women. They can be overcome. So there also we can say this is an issue that might be addressed by other than repressive means. Moreover, I would say subjective safety fails as a justification ground for the bans because the safety risk cannot be objectively grounded. It's not just because you fear people with piercings that this is a ground to ban piercings. So there should be some relation to objective safety. So what about that? What about the argument on objective public safety? If there's a real safety risk, of course, it can be a ground to restrict religious freedom. But it cannot be based on speculations alone. There is case law of the European Court of Human Rights, a case named Ahmed Arslan, where the European Court found a violation, assessing a criminal conviction of members of a religious order who were convicted for wearing distinctive religious clothing in public. And the court found a violation because there was no evidence of an actual threat to public order or of engagement in proselytism. Now, in any case, it would appear difficult to reconcile the ban's broad scope, all of public space, on all of the territory, with the principle of proportionality, which is about tailoring your measures to a need. So in most cases, safety risks can be overcome by less restrictive measures than a ban, such as the obligation to lift the face veil upon a legitimate request to identify. Safety seems not to require permanent recognizability. It seems to require simply identifiability. And among our interviewees, we found a general willingness to identify themselves to the police or other authorities by lowering their veil, with many even stated that they would unveil before a male official as well as for a female official. So the risk of the face veil for objective safety in the general public sphere appears exaggerated, if not entirely unfounded. So if the legitimate aim is safety, again, this is a disproportionate measure. Now, what then about banning in the name of women's rights? Well, discourse about women's rights, women's dignity abounds in the parliamentary debates in France and Belgium, using very strong language like a mobile jail, a textile prison, the shroud of freedom. The underlying assumption being that women wearing a face veil are mostly or always forced to wear it. But, as I already said, all available empirical research shows that this central assumption is erroneous. So the research does not allow to conclude whether, and if so, how many women might be forced to wear a face veil, but clearly shows that significant numbers of face veil wearers, like we interviewed more than 30, and their estimates are that there are maximum 150 in the whole country. So it's really significant numbers of face veil wearers wear the face veil as a result of autonomous choice, with all of them describing this decision as a well-considered, free decision, a personal trajectory, really, of deepening and perfecting one's fate. Not an easy decision, by the way, because in France, Belgium, and the Netherlands, nearly all face veil wearers were faced with very strong negative reactions from their close environment, their relatives, their friends, sometimes even their husbands. So overall, the women's agency appears to be a very determining factor here. And so no surprise that these women generally see themselves and each other as strong women. It takes one to wear a face veil in a place like Belgium. So these women experience this ban, of course, as a denial of their autonomy, as anti-emancipatory. So to the extent that the niqab is chosen freely, a ban based on the protection of women's autonomy makes no sense. Moreover, research in France after the ban shows that this ban has made married women more dependent on their husbands, because it's now the husband who has to do everything that has to be done outside of the house. As she loses her autonomy, she goes out less. By contrast, of course, forcing a woman to wear a burqa or a niqab, of course, that's horrible oppression of women. But as we discussed already, it is very doubtful whether criminalizing and fining the women in question can be considered a relevant measure to combat this oppression. It's an approach that treats the oppressed woman as a perpetrator rather than as a victim. So it seems that protection of these women against imposed feeling cannot justify a face covering ban under the European Convention either. Now, that's not the end of the story on women's rights. Close reading of the debates on face veil bans reveals that the women's rights argument is not necessarily focused on the rights of the face veil wearers. Regularly, this is expanded to the rights of all women for whom the sight of a face veil would be an offense. So in legal terms then, the question is whether you can ban the face veil as a symbol of women's oppression. Now, as the empirical research shows, it is a strictly outsider interpretation of something that is not, does not carry this meaning for the persons involved. That is highly problematic, but also prohibiting symbols is virtually always at odds with free speech, even in Europe. In the US, that's rather self-evident, but even in Europe, and I refer to a case of the European Court of Human Rights, Vajnai, where the court ruled that the application of a Hungarian ban on communist symbols to a person wearing a red star in a manifestation was a violation of free speech, even recognizing that this might bring back bad memories for many people. In Hungary, the court stated there are multiple meanings of this symbol, and there is no real danger of violence or disorder here. So I don't see any reason to rule differently on the face field as a symbol. So to conclude, from the perspective of the women concerned, face field bans are counterproductive with respect to all three of the stated purposes. They restrict women's rights instead of furthering them. They reduce social interaction, and they expose these women to serious safety risks. Yet, the French and Belgian legislators were not really concerned about the impact on these women. They were concerned about the impact on the people who are confronted with women wearing a face veil. People for whom the sight of a face veil is an affront to human dignity, who do not want to interact with women wearing a face veil in a shop or in the street, and who feel unsafe when they come across a face veil because they associate it with terrorism and fundamentalist Islam. So for those people, the fact that there are fewer face veils around on the streets in France and Belgium is an improvement on all three fronts: women's rights, social interaction, and safety. But our research has also shown that solutions promoting women's rights, social interaction, and safety for all, without resorting to repressive means, are possible, are also an option. So will the European Court of Human Rights in the SAS judgment force European states to withdraw their face veil bans? If the court takes empirical reality seriously, I don't see how it could uphold the bans. Yet the risk remains that the court cannot bring itself to look through the eyes of such a very different other, and that it simply accepts the state's justifications based on widely shared assumptions and majority concerns, much like the French Constitutional Council and the Belgian Constitutional Court have done. Thank you.
Well, thank you very much for the opportunity to participate in this discussion. I want to begin by saying that I almost regret what I have prepared for today, and I regret it for two reasons. First, because I think many, if not most, or not all of the points I want to make have already been made in one form or another, so I'll be sort of reframing them. But also because of the discussion that we've had this morning has been so interesting, I almost feel that I should have engaged the issue differently. And let me explain. What I'm going to present to you is an attempt to conciliate the tension between what I think, or I suppose may be a legitimate claim or concern with women's equality, being put forth by those who propose banning veils. And here I'm very consciously trying to separate those who are projecting what I think is, and I think the French case here is the most evident, are projecting basically discrimination on other groups, from those who legitimately feel that the veil is problematic. And not only the French have gone astray, and I think in the case of the French case, it's pretty evident when they bring in the civilisation française as a justification. It's pretty evident that it's not really women's rights, but rather cultural hegemony that's being put forth. However, there are feminists, at least in Mexico, some of whom I respect, admire, and have deep affection for, who have strong feelings about the veil. And so I'm thinking, or I'm trying to articulate a constitutional doctrine that, or a constitutional argument that will conciliate that concern with what I believe is the proper position in this matter, which is to respect women who choose to wear the veil. So my proposal tries to disengage the tension between religious freedom and gender equality. But after the discussion today, I feel like I almost want to not disengage the tension, but rather exacerbate the tension, because I do think that this issue in particular is a wonderful entry point to what I believe are the deep structural, genealogical, ontological problems with human rights discourse. And so while I very much enjoyed Professor Ahmed An-Naim's proposal that human rights be understood as implying necessarily the inevitable relativistic nature of our humanity, that is not where I read the human rights discourse coming from. And this may be my concern with genealogy and history of legal thought, but the human rights discourse, contrary to what most of us tell ourselves, is not something that begins in the post-war era in the 20th century, but rather it stems from the process of colonization of Europe, of this continent. The process of colonization of which this country and my country are a byproduct, and the process of colonization which used human rights discourse to justify the violence exerted on this population, because the first human right that was being protected by colonization was the human right to know the true faith. And so military incursions were justified, at least when it got sophisticated enough to actually need justification, on the grounds that preachers were being held back from reaching the populations that had a right to know the true faith. And thus, military incursions to protect those priests justified conquest. And human rights discourse was also very present in the plead not to exploit and exterminate the native population, but rather to import African population and exploit and exterminate that population. So human rights discourse is enmeshed in imperialism from its inception. And that is something that I think is coming up in this discussion, and I think there's a great entry point, and unfortunately it's something I did not prepare to speak about, but I wanted to, provoke a little bit. So what I do want to say here is, okay. How does this work? So the way I want to think about this issue is not as a tension between religion versus equality or religious practice versus gender equality, but rather about an issue regarding speech. And this is a constitutional framing which, independently of the very important empirical work that I believe needs to be done and apparently is already being done, but is not as present in the legislative debates, this is mainly a concern with framing, with constitutional framing. So the premise tends to be in this framing the issue as a tension between religious attire, and that is religious versus equality, as that what the attire question says about women is at least not valuable. If protected, that is, it is protected because it is a collectively held belief. The burqa is something that may be or may not be valuable because it is part of a religion. And what I want to propose is that the burqa be considered something of value because it says something about gender. When somebody wears a headscarf or a burqa, she is saying something about gender. She's not only engaging in a religious practice. And from this perspective, I think that warrants constitutional protection or fundamental rights protection or human rights protection, whatever the jargon we want to use. So the question when the whole architecture is religion versus equality is, should gender equality prevail over religious freedom or vice versa? And I think this is a no-go. I think there's several problems. First is that it presents two incommensurable values that clash, and so there's very little common ground to decide upon, and you basically are forced to choose between these two values. And second, and this is for the gender equality advocates, first of all, prohibition is always problematic. This I've learned from my initial support on the ban on pornography proposed in the 80s by McKinnon, and my later reconsideration of that in light of my former research assistant's enthusiasm for feminist porn. But secondly, and this is I think very important, is that casting the issue as a religious question disempowers women. So those who want to empower women are actually disempowering women when they claim that women are only victims or collaborators in wearing their headscarves. So it's a no-win situation for them. There's no agency that's being recognized in the women who choose to wear these scarves. So what I basically propose, and this may be a bit boring for those who are not in academia, but it's basically Joan Scott meets Owen Fisk. So let's think about gender. Gender can be constituted both about speech regarding gender, but also about gender itself being a form of speech, saying things about the meaning of what it is to be a woman, what it is to be a man, and the Fisk approach to free speech emphasizes the idea that free speech protections should seek diversity and inclusion in public deliberation. So a plurality of perspectives is one of the guiding principles of free speech. So in that sense and under that understanding, we need to think about the burqa expressing a specific conception of gender, not so much embodying a religious practice. I mean, of course, it embodies or it may embody a religious practice, but it need not only be that, and it need not mainly be that. I believe that when a woman wears a headscarf or a burqa, she wants to say, she's not only saying, I belong to a certain religion or to a certain interpretation of a religion. She's also saying something about the role and the place she believes women have in the world and should have in the world. And maybe I don't appreciate what she has to say about what women do in the world and should do in the world, and maybe I don't agree with that, but I think for the sake of free speech, in the understanding of wanting to promote diversity, I need to accept the fact that she can propose a version of what it means to be a woman that is different from the one that I agree upon. And of course, she's not only saying something about what it is to be a woman, she's also saying something about what it is to be a man. And I think it's also important that I at least have the capacity to hear what she has to say about being a man. I mean, one interpretation of the burqa, and I'm caricaturizing here, is that us heterosexual men are so animal-like that we will not be able to control ourselves upon seeing a lock of hair, right? And it may be so. And I think it's important that somebody say it. Or rather, I think it's important that if somebody wants to say that about men and women, that she should be protected in saying it. And if she wants to say it through her attire, then I think that is valuable. So attire is a dimension of gender that involves speech, is basically the way I think we can frame this. Attire says something specifically about gender, according to a specific worldview, not generally about religion. Because, see, we cannot disengage the gender dimension of wearing a veil, because not all Muslims wear a veil. Not all Muslims in all Muslim interpretations, but even within those interpretations, not all Muslims wear a veil because some Muslims are men and they don't wear a veil, right? So even within that worldview, it is something that's being said about gender. Gender and in the intersection of a religious belief, yes, but gender in the end. And so the common ground here, I think, that we can find if we recast the issue not about religious practice versus gender equality, but rather about gender speech, is that it is valid for somebody to say about gender that women should be behind a veil, as much as it is valid for somebody to say about gender that women should not be behind a veil. And in this sense, in both cases, and this is the main point, by framing the issue not about a religious practice but about the expression of gender, or expressing something about gender, we are locating the fundamental right, the claim, the title holder, we are locating it in the woman. The woman is empowered either way, whether to say that she thinks that women should be behind a veil or to say that she thinks that women should not be behind a veil. If that claim is thought of as a religious practice, then it is not her who is entitled, but a community that interprets the world in a certain view. So I want to locate the claim to a human right or to a fundamental right in the woman. If the woman chooses to express something about gender roles that I do not agree with, tough cookies. But it is she who is empowered. And that, I think, is a radical change, because it empowers her not only vis-à-vis the state, but also vis-à-vis her own community, in case she would choose to say something different about gender at a different time. The second difference that I see is regarding rigidity. If it is my speech that is being protected, then this is more ductile. Speech can change, I think, with far more ease than religious practice can. And making a claim about me changing what I want to say about gender is more easy. It is easier than making a claim about me changing something about my religious practice. And so changing what you want to say about gender, so going from wearing a headscarf to not wearing one, is equally constitutionally protected. Whereas if we're thinking of it in terms of religious practice versus gender equality, I lose the protection when I disengage from the religious practice. Here I keep the protection, whether I disengage or disengage with that practice in specific. And this is actually I think that the net effect is that whereas we think of it as speech, it tolerates, empowers, and holds responsible, and this is, I also think, is important, it holds women who wear the headscarf responsible for saying that and for assuming that about gender, and with responsibility, I think, comes power. Whereas in sending out the message that you are disempowered, you are a victim, or you're a collaborator, you are not holding them responsible, and therefore you're not communicating the idea that it is a choice that can be made. And finally, whereas diversity is protected and stimulated both within the community at large and within each religious community, in casting this as an issue of speech, it's diversity stifled if we cast it as it is being cast. And just finally, one last argument that came from the comments. I think one of the reasons that nobody is discussing banning breasts on page 3 is because everybody assumes that it is a question of free speech. And within European societies and Western liberal states, free speech does have a particular cultural thrust that gender equality does not have. So strategically, using speech seems a good idea. That's it. Thank you.
Next and last, we'll hear from Lucy Vickers.
I'll just use the first minute just to do what Shami's asked me to do, which is to confirm that she's not my boss. So I'm telling you because she told me to, and then so I thought what I would do, I've got a range of comments coming out from what's come up so far, but I thought it would be useful just to, can you hear me now? Yeah. Is it working? Is it working now? Yeah. I just wanted to think a bit further about the headscarf ban, although it does raise issues about other religious symbols as well. But the first is just to raise a few comments from the point of view of gender equality about the idea that bans in any way can be seen as a sort of neutral statement. So that a ban on religious expression in the public sphere is in some way enforcing some sort of state neutrality. Because clearly just it's clear that strict neutrality clearly fails any test of equality, because our social organisation is never neutral. And we can see that learning from some of the feminist perspectives that we are all familiar with. So the two problems of assuming that our public sphere can be neutral, is that within many Western European countries, certainly our neutral public space has a much better fit with the dominant Christian tradition. And if we think about the feminist insights about the neutral norm tending to be a male norm, we can see parallels in relation to religion as well. So our social organisation is largely Christian rather than neutral. Our working practices, our working year, our working week, all rely on a Christian norm. And that may be have historical bases, but I think there's also an aspect in which Christianity itself has adapted to a secular sphere as well. So it's not only to do with the secular adapting to Christianity, but it's also works the other way too. In simple ways, Christianity has adapted to or took on pagan festivals. So we have Christmas at the same time as we used to have a winter festival. So we can see Christianity being a very adaptive religion as well. Some would argue that it's actually Protestant Christianity in particular that is this adaptive. So it's adapted its theology to an idea that separates body and mind, with a faith based more on the mind than the body. And that maps nicely onto an idea of a separation of church and state. And it allows Christians, or Protestant Christians at any rate, to meet these neutral demands in terms of dress codes or lack of dress codes, because their religious practice is based more on personal belief or orthodoxy rather than orthopraxy and the ideas of expressing your faith through the body and dress codes or grooming codes. So I think that's worth just bearing in mind, the way in which the religions, the dominant religion has adapted itself as well as the dominant culture adapting to Christianity. And that particularly means that these ideas of bans that have an impact on other faiths involve a lot of unequal treatment. And the other idea I think we can get from feminist thinking as well is that suggesting that personal matters should stay out of the public sphere doesn't just lead to personal matters staying out of the public sphere, but to persons staying out of the public sphere. And we can see that particularly in relation to women and the empowering of women to participate in the public sphere being necessitating some social practical change. So if we want women in the workplace, we need to sort out childcare. And we know that, and feminist thinkers know that, and I think it's important to bring some of that idea and thinking into this discussion and debate about religious dress codes too. That if we want Muslim women to participate in the workplace, to participate in the public sphere, then we need to enable them to do that and empower them to do that by enabling them to bring their dress codes with them, if you like, and participate. And I think you can see a lack of understanding of that in the French ban and Sarkozy's comments, where he said at one point when somebody was saying, but how are these women going to go out? And he said, well, they can wear, if they want to wear their headscarves, they can wear them at home. And I just thought that was a wonderful illustration of the lack of understanding that people don't wear them at home, and that's the whole point. That, it's not sort of empower these Muslim women to wear their headscarves at home. So if we ban the religious clothing from the public sphere, then we actually effectively ban the people themselves. And so I think the idea of this neutral ban, or this somehow reflecting a neutral public space, is misguided. So instead, I think we have to have a much more subtle and proportionate response. And so my argument around this has been that we need to have to use the language of human rights and the language of proportionality in particular to help us to reach some sort of an answer. And as Eve has said, the human rights thinking on this means that you have to have a legitimate aim to any ban, and you have to be able to justify what you're doing in terms of proportionality. And clearly there are a range of competing interests at stake, which we've heard about, equality interests of women. Of course, that's interesting if we go down the route of bans for religious symbols that affect women in particular. in the name of gender equality, because of course we don't then know what to do about all the other religious garb that people wear. So there's been a recent case in the UK. Most of the cases involving school children have involved wearing of headscarves and the jilbab, the sort of long, loose garment that Muslim women wish to wear. And there's a recent one now about a teenage boy who's grown a beard, and whether or not he should be required to shave and be clean shaven at school. And that clearly doesn't have anything to do with women's oppression, but it would seem rather peculiar if we end up with a rule that says, well, the boys can have a beard, but the girls can't wear their headscarf. So then we've got an inequality creeping in there. In relation to the proportionality as well, I think the balance also needs to take into account quite a lot of contextual factors. And if we think about the employment context, matters seem to me there to be quite different. I think it's too simplistic to say, well, you can leave your headscarf at the workplace door, and you have no rights to religious expression at work. But nonetheless, there are quite a few other contextual issues that we need to take into account in relation to the workplace. We're quite used to the workplace restricting our autonomy in lots of ways. Whilst I don't have restrictions on dress code, particularly in my workplace, there are certain things that you wouldn't wear. You're not going to turn up in a bikini, you're not going to turn up in probably too scruffily, although actually in academia that probably doesn't quite apply. But generally there are dress codes that we comply with, and so we're not talking about such fundamental free speech ideas that, in the workplace. And there are also aspects of the job, clearly, that sometimes will require restrictions. In the UK, one of our cases, a case called Asmi, involved a woman wanting to wear the niqab as a school teacher. She was a classroom helper, and she helped children for whom English was a second language in the class. And she wanted to wear the niqab during school, and she was prevented, and she left. And this was treated as an indirect discrimination case, or a disparate impact case, and the school's decision to dismiss her was upheld as proportionate. One of the things they'd done in that case was to actually do quite a bit of research and investigation to see whether or not her communication was reduced by wearing the niqab. And they trialled her teaching with the niqab and without, and they found that the children were better able to understand her and listen and communicate. The context is all important there. She was teaching, she wasn't the teacher at the front of the class even, she was helping a small group within the class. And clearly, therefore, she's not going to be able to stand and project her voice because she's going to disrupt the rest of the lesson if she does that. So it's a question of keeping quite low voice. And they felt that the children needed the non-verbal communication that would come from seeing her face in terms of better communication. Another context-specific case in the UK is the case of Begum, which involved a girl who wanted to wear the jilbab, the long, loose sort of cloak dress over her uniform, and she was prevented as well, and that again was upheld as proportionate. And again, I think this allowed the decision of the court was very fact-based and fairly nuanced. It involved considering a lot of very particular factors. One was there was another school down the road that would allow her to, so she wasn't being prevented from a right to education. There was also some discussion, and they'd had quite intensive discussions about the impact on other girls in that particular area, feeling under pressure to wear this type of more conservative dress. And the school felt that by having a rule about what you could and couldn't wear in the school, this freed the girls who were claiming that they didn't want to wear it from that sort of social pressure. I think social pressure to wear religious symbols in the public sphere is a very dangerous factor to take into account when we're saying what people can wear in the street. I think in the school, given the context, the age of the children, and the very specific questions that have been asked in that case, that the outcome was probably correct there. It allowed the case was very fact-specific and very nuanced. So the idea of using proportionality, I think, is highly beneficial because it allows for a much more nuanced, case-sensitive, fact-based decision rather than a blanket ban that says for all people at all times in all public spaces you can't wear this religious dress. it also allows much more nuanced consideration of the costs or the negative aspects of banning certain religious dress. The implications about us making decisions about what the religion requires, or the state making that decision, the issue about how that's perceived by the women to whom it's directed, and the influence of the idea of controlling of women and what they wear. So a case-sensitive approach seems to me the best way forward. The danger, of course, of this fact-sensitive, nuanced approach is that it gives us no clarity whatsoever about what we think should be done. And it allows for lots of case law. It allows for lots of work for lawyers. It gives, it's a field day. It means everybody who comes along and says, can I wear my headscarf to school, please? Or can I wear the niqab? Every lawyer's answer has to be, well, it depends. And it depends on, are you a monopoly employer, for example, or are you not? Are you a public sector, private sector? What's the culture in your immediate locality? What are the messages that's sending? It becomes a very subtle and context-dependent decision. And I think that's its cost. But I would still recommend it as the way forward, because I think it allows us to get to better answers. And there's clearly no right answer in most of these cases, but there are perhaps better answers rather than less good answers. And I came across an article written a number of years ago in a tax journal that was called "It's the Best Answer, Not the Right Answer, Stupid," which I rather liked, as a way of trying to get a way forward, that we're not necessarily going to reach the right answer on this, but we need to be seeking the best. And the way that we get to the best answer is to have a legal structure that allows for the nuance, the complexity, the debate and the contestation to come in. And if we go for a single ban and a single rule, we just get a very blunt instrument that doesn't allow for all of that. So I think the idea of a ban is wrong, but it's more because I think we want to keep complexity in and keep the discussion and the debate going, because that way we get to a better answer, if not the right. Thank you.
So let's have a little discussion before lunch. I think I agree with the conclusion that everyone has reached, which is that there's something very problematic about these bans. But if I were to push back against some of the arguments, I might say something like this. I mean, for Eva, for example, once you take into account the role of will formation by tight-knit religious communities and the possibility of dynamism in religious belief and the possible interaction between state norms and religious norms, I wonder if it becomes a little bit more complex. So I was thinking about the polygamy ban in the United States that was imposed on the Utah Territory toward the end of the 19th century, right? I mean, if you had conducted empirical studies at that time of women who were involved in polygamy in Utah, you might well have, come to the same kinds of conclusions that you have. Nevertheless, we might think that it's quite important to impose that kind of ban in order to encourage dynamism, change over time in the beliefs of particular religious communities. By the way, that ban on polygamy was imperialistic in the literal sense. I mean, Utah was a territory; it was part of the annexation of Utah by the United States and so forth. So I wonder if thinking about the processes of will formation in tight-knit communities would lead to any sort of kinds of conversations there. And for Alejandro, I thought it was a fascinating proposal. But I kept wondering whether Owen Fiss and his approach, or similar democratic theories of free speech, wouldn't actually sort of see speech concerns on both sides. So this then becomes a kind of not weighing of incommensurabilities, but a weighing of commensurabilities. Namely, there are speech interests on both sides. And if we allow the practice of the head covering or face covering or body covering in public places, that could actually have a silencing effect, not only on the women who wear this, but also on other women. So there's a net decrease, right, in free speech ability or values if you allowed it. I wondered how you would react to that. And if anyone else has questions, I'll take a cue. Yeah. Do you want to react?
Can I answer your question?
Yes.
And then also react to Alejandro?
Yes.
Okay. Yeah, it's a very important comment you put. How much free will is there? Isn't this a matter of group pressure, etc.? Now, when you're talking about places like France or Belgium or the Netherlands or Denmark, you're not talking about whole communities of women adopting the niqab. You're talking about actually rather isolated women who didn't necessarily, most of them actually, didn't know personally anyone wearing a niqab before they made the decision to wear. This is very different in the UK, where you're talking about much larger numbers. So these are isolated women. Really, it's a very private thing, a private journey they are making. So community pressure, there's a lot of community pressure on these women to not wear it. I mean, in their community, their parents, their sister, even in many cases, the husband. So that not. Is there pressure from the husband to wear it? Some husbands are very happy if their wife decides to wear it. It fits for some of them really in the image they want to project of their family as a orthodox family. Others are very so that tends to vary a lot. Clearly, I would say from a radical feminist point of view, there's a serious issue here. This is about, there are dominance issues, etc. But from a radical feminist issue, there are other things. So, look what I'm wearing. 10 centimeters.
I don't know what a centimeter is, but that looks pretty good.
Look, it's the same. I would submit it's the same thing. I'm a feminist. I know what I'm doing here, how I am positioning myself in this field. It's a choice I can make, strategically or whatever. So, then we have to be consistent. If we're going to ban face veils or even hijabs on grounds of such radical feminism that really uncovers the hidden dominant structures there, we have to be consistent and ban a lipstick. Yeah, you're also guilty. That's at a deeper level. Of course, there are issues about gender and women's rights. Now, why I wanted to give a comment also on Alejandro, I think. Strategically, it's very attractive what you say. And certainly in the European Court of Human Rights, one has a much better chance to win a free speech case than to win a religious freedom case. But sort of my ideology in this matter is that the human rights framing should be as close as possible to the lived experiences of the individuals themselves. And then what you find, like I said, in the countries we're talking about, they're not making a statement. They're really not making a statement. It's a very private matter that they are doing for themselves, for their conscience, for their relationship with God and hardly anyone else. So it's not a statement, and certainly not a normative statement about what women should do. Trying to persuade others to also take this step is very far from their minds. In our research team, we were joking about it, that because we did not expect this, that this was because I want to be the only one and so the best Muslim in the neighborhood or something like that. They didn't want any competition because they certainly didn't want to persuade others to wear it. It was very much a trajectory. So is it saying something about what it is to be a woman? I think in the first place, if you really want to see it as a statement, it's a statement about religion, about submission to God, about the attractiveness of the model of the Prophet and his wives, about such things, but not so much about what it is to be a woman, except maybe, but not for all of them, chastity, as an acceptable alternative to the dominant Western view. But some of the women we interviewed denied that outright as a motive. There was a hilarious scene during a focus group when they were sharing their experiences about actually having more men pursuing them once they started wearing it, and how it wasn't that. But to the extent, chastity also is not the same thing as protecting against men who would be of such a nature as to attack any women they see uncovered. It's also more about not inviting the gaze of men. So it's also still a different thing, I would say. So to the extent that there's a message, it's a different message. I would like to say. In the Belgian study, because I'm very interested in gender views, we asked a lot about gender views. I mean, indirectly, because you can't ask, like, what's your position on women's rights, but indirectly about how their daily life, etc. And there was a very wide variety. There were those that would say, I think the place of woman is at home, and I like to be the queen of the home, etc. Typical conservative Islamic viewpoint. But there were others who really had modern views, I would say. We're saying things I could say myself about how the man should do his share in the household and all that sort of stuff. So it is more complicated than that, and I'm a bit afraid in seeing it as the expression of a message that we might distort what's actually going on.
So we have 10 minutes. You don't know what that means. But I know Alejandro wants to get back.
Yeah.
But also wanting to speak, we have Shami, Robert, Margaret, Robert, Anthony, Fred, Hagai. So just keep that in mind as you answer, so we can maximize the participation.
Well, so quick reactions. First of all, if it's not a message, it's not a message. And I think that it's very important to actually understand what is going on. Now, how to understand a message and how to understand expression is a whole other issue. So, for example, I think that marriage has to do with my relationship with my partner, maybe my relationship with God, if at all, or with the state. But it also has a very deep expressive dimension, and particularly the claim for equal rights in homosexual marriage has to do. And this is, I'm thinking from the Mexican case specifically. We had civil unions in Mexico City before we had marriage, gay marriage. And civil unions were practically unused. There were, in a city of 20 million, 500 civil unions in 4 years. And then the minute that a marriage came into the picture, within the first 3 months there were 2,000, something like that. And I think part of choosing, I would tell everybody, choose the civil union. It's a far more civilized legal regime than the marriage regime, right? But part of the point was my union is of the same quality and nature as your union. It's not separate but equal. It's not mine is civil union, yours is marriage. Mine is as much as marriage as yours is, even if it is a worse legal regime. So there's a whole dimension of what we mean by expression. Now, there are cases which I think do have very direct impact in expression, and some were mentioned here, and the occupation of Iraq having as a response more women wearing the headscarf, or a younger generation trying to affirm an identity vis-a-vis a broader generation. So in the extent that it says something, I think it should be protected by free speech. And of course, and I confess, it's a tactical move. If it doesn't, and if there's no speech involved and there's no message involved, then of course my case has no grounding. Sorry, Sorry, I was going to respond to the other question, but I see you.
Go ahead.
Okay. Basically, yes. Of course, there's speech issues on both ends, and that's why I'm proposing it, because that way we have commensurability and we have a common ground on which to try to understand specifics and particular problems. And it's not going to be the same if I'm a 16-year-old girl in London wearing a headscarf than if I'm a 12-year-old girl in London wearing a headscarf, or a 16-year-old girl in Iran wearing a headscarf, right? So these are just very schematic framings that I'm proposing, and the whole point is that we will have tension within a same value system, so to speak, which may allow us to have more significant, permanent, stable, and inclusive. Everybody feels included in some way and not excluded with the solution.
Just very briefly to respond to these two, I knew that we would mix it up as scruffy activists and they would sort it out as learned academics, and I was not disappointed. I think that on this speech issue, I think they're both right, because I think that human rights are indivisible. And we find these ways of describing human dignity and in all its manifestations, but in the end, rights and freedoms are indivisible. And I thought what was very interesting and provoking for me from Eva was really that when this is supposedly a feminist measure, and it's about other women not wanting to see this particular garb. It's almost purporting to suggest a right not to be offended, and that is the one right that must never exist. This is the one that so many people claim, but it must not exist. And I think careful what we wish for as bourgeois liberals, because the people who want a right not to be offended by the sight of a woman dressed a certain way are just as bad as those religious communities who don't like the Danish cartoons or Monty Python. That's the right not to be offended, and it must never exist. And on this kind of it's about speech thing. Yeah, I do. I think it's expression, and it can come from your conscience, it can come from your faith, it can come from your politics. It is an expression of your autonomy and your dignity, and therefore it must only be limited for good cause. And it's about being true to our values and judged that you be not judged. That's Matthew, I think. And applying these with an even hand.
Robert.
A comment on comparing Alejandro and Lucy's presentation, and a quick comment on Eva's. If liberty, freedom of speech versus equality, avoiding indirect discrimination based on religion. I found your approach very interesting, and I think it works well in the street. My two reservations are, one, in Europe a lot of people see a headscarf as sending a message, whereas Eva said it's actually, many women would say, no, I'm not sending any message at all. But a message is imposed on it, which is basically, I support an Islamic extremist takeover in Europe, ideally of the Afghan Taliban variety, which is rather a lot to read into a piece of fabric. So that makes me uncomfortable to put it on the terrain of free speech. And the more practical concern is, as I say, it works well in the street, but what happens when you go into the workplace, where employers may have a greater discretion in restricting employee free speech, if you characterize it as speech, than if you say, no, this is a religious or cultural practice, and as Lucy said, excluding the personal from the public sphere will exclude the person. So it's about avoiding exclusion of ethnic and religious minorities. And then with Eva's conclusion, I like to try to share her optimism about the European Court of Human Rights, and I think this SAS versus France case is very important because the court has yet to stand up to Islamophobia in Europe. The first chance was the headscarf cases. It refused to intervene. Second chance was the ban on minarets in Switzerland, and there were technical reasons to reject the case, and it seemed the court was quite happy to use those. This one's unavoidable and really extreme, and if the court is not willing to draw the line here, where will it draw the line?
It's Maggie, actually.
Okay.
I just wanted quickly to add another equality dimension, and that's race to the discussion. I work for the ACLU in California. It's a obviously religiously pluralistic state. It's a racially pluralistic state. And while it's true, as people have said here, that when we deal with this issue of attire, and it's one of the most frequent complaints we have, there is a religious disrespect. For example, we represented Sikh school children who were expelled from school because, as very devout Sikhs, they had to carry 5 sacred symbols, and the school was saying, well, you can't do the little ceremonial knife. What about 4 sacred symbols? Close enough for government work. And we deal with it in the workplace when somebody has a Hindu piercing, for example. Suddenly that's unsanitary. But with all of that, I want to say that when we look at the complaints we get, there is very frequently it is the racial minorities, the people of color, whose religion particularly becomes the other. And it's interesting to hear this discussion about the veil. and there's without a racial dimension. I mean, maybe in America we see everything in those terms, but I do think that what's exacerbated the imperialism and the cultural disrespect is also the racial tension.
Anthony Romero.
With as activists is how to make these rights universal and indivisible. And that's where we earn our pay as activists. And that's often where I think the human rights community falls short in the tough cases that really are about universality or indivisibility. And I've always thought like the context of religious freedom and equal treatment is one of the places where rights were seen as not as universal, right? The rights of women, the rights of LGBT communities don't have the same resonance in all cultures and contexts as civil and political rights, the right to protest, the right to vote. But when you really look at it much more closely, for us as practitioners, we find a hypocrisy even in the civil and political rights context, right? I mean, we've heard from Hassam over the last several days about how muted the voices are of human rights activists in Egypt decrying the crackdown on the Muslim Brotherhood, the atrocities, the murders, the killings, stuff that he knows much better than I. I think about the hypocrisy that my own organization suffered from good rights liberals who criticized us for defending the rights of the Nazis, the neo-Nazis, to march to Skokie, Illinois. Because those rights are not as universal as we'd like to believe, even in the civil and political rights context, even today. And the battles we have with some of our LGBT friends who say, well, you should not defend Fred Phelps in the Westboro Baptist Church, or you should not stand up for some of the zoning laws around abortion protesters, anti-abortion protesters. So there's a real breakdown for us as rights activists about whether or not these are truly universal. That's where we earn our pay, about asking ourselves a question, whether or not we're willing to stand up for ones that we really understand the principle but don't understand the facts exactly the way we'd like to live our lives. And the indivisible, I find impossible to practice as an activist, right? Because when you want to move the ball forward, you want to move the ball forward. And so you'll make some decisions on divisibility to make progress. LGBT, I can't tell you the number of times we have real hard conversations around LGBT issues and whether or not to add the T, transgender, will hurt our ability to move the LGBT agenda forward, or whether it hurts us. Everything from federal laws, do we want to push as hard for transgender protections in ENDA or not as hard? And I think that's ultimately where I think this context is so important for us, because we do have to earn, if we believe in the universality and the indivisibility of it, then we've got to be willing to take some very tough stances that are often very much at odds with either the interest in moving the ball forward or even defending the rights of people we really don't like. And I find that is a place where that's what separates the wheat from the chaff, frankly. I don't find a lot of human rights activists willing to defend the rights of people they ultimately don't agree with, detest, despise. I think that's what sets apart Hassam in Egypt, where defending the rights of the Muslim Brotherhood to vote, to protest, to be free from killing, and you find our government muted, you find human rights activists in this country muted, you have international human rights NGOs muted. And I think that's ultimately the real, it's an academic conference. It's a little bit of the existential crisis that our community confronts when we actually have to pick real cases and real clients and real controversies and not just theorize on how good these values are, but actually practice them. So it's a comment more than anything.
Thank you. For those of you who don't know, Anthony is executive director of the ACLU. So let's just, at the risk of making enemies, let's collect just the three remaining comments before we go to lunch from Fred, Hagaya, and Noah.
Mine's just very brief. An observation, really. It seems to me that there ought to be an extremely strong presumption, if not a conclusive presumption, that women dress the way they dress because they choose to do so. And that the burqa controversy, in a way, is yet one... Oh, I'm sorry. I was just saying there ought to be a presumption that women dress the way they do because they choose to do so, and that the burqa controversy is yet another example of refusing to take seriously what women say they're doing and why they're doing it, and one in which, ironically, some feminists are complicit.
I found all three presentations very interesting. For lack of time, I apologize, and I'll only relate to one of the three. And I listened very carefully to the construction of the argument that Alejandro made in the context of what does wearing a veil say about heterosexual men. And at one moment I was thinking that maybe you're going to go the next logical step forward and contemplate the possibility of banning heterosexual men from public spaces. Now, it was meant as a joke, but obviously it's not just a joke. And I don't know if this is an existing academic doctrine, but as a rocket scientist, maybe I'll invent one. And it resonated from a very different case that ACRI had with regard to segregated roads in the occupied Palestinian territories, a road that was, at some point, the state banned access from Palestinians to a road, only keeping the road open for Israelis in the occupied Palestinian territories. And obviously the analogy is that the ban that dared not say its name in that context was the possibility that the state never considered of banning that road to Israeli traffic. And the doctrine that I'm suggesting is that it may be constructive in these cases and other cases to always explore the alternative bans that are never suggested, and what does that say on the power structure, on the power relations, and so on.
Finally, Noah.
Just wanted to throw out a couple of comments and one question. I think, while we don't see a lot of niqabs in Toronto, which is where the Canadian Civil Liberties Association offices are, we do see a lot of hijabs, in particular in certain communities, I'm in the schools quite a lot, and it certainly seems to go with any other trend and any other form of peer pressure, and I would be very interested in hearing about that, maybe over lunch, talking to people who know about it, and especially you, Eva, who's done the empirical research. What does that mean? We're talking about dynamism, and certainly dynamism can go in any which way. The other thing I wanted to mention, just because you were talking about nobody being forced to wear the veil, I think, again, we were talking about the hijab, not the veil. There is a famous case, an infamous case in Canada of a teenage girl who was killed by her father, according to the press, who is notorious for getting these things wrong, especially when it comes to Muslims. But that said, according to the press, the reason that he killed her was because she was refusing to wear, I think it was a hijab. So I wonder how many other cases there are out there where there actually is a form of actual coercion. Not that a ban is necessarily the answer, but that this is going on, and what would have happened in this young girl's life had there been a ban on hijabs. Again, not that I'm supporting it, although one of the provinces of Canada is. And the last thing that I wanted to raise is a question, because everybody seems so comfortably satisfied in the idea that this ban is wrong. And as much as I agree with that, I'm never comfortable when we all reach a consensus. I mean, something must be missing. I wanted to raise the question that nobody's yet raised, which is about freedom of conscience. So, heaven forbid, and I use the term advisedly, that we should elevate religious freedom over freedom of conscience. And what does it mean if I have a deeply and sincerely held belief that I need to have piercings or tattoos or green hair or whatever it is that my workplace or my society finds unacceptable, or be nude, or whatever it is that society doesn't allow me to?
And where does that fit into the picture? Because a little crucifix may not harm anybody. I don't know that green hair does, and yet it probably violates a whole bunch of dress codes. So throwing it out there. Thanks.
Thank you so much. This has been such an incredible conversation. I've really enjoyed it. I wish we could go all day, but people need to eat.